Welcome everybody to the meeting. Notice of the October 3rd to 5th, 3 to 5, 3 to 5th, whatever, 2018 meeting of the Board of Architects and Engineering Examiners is called to order. The meeting was posted to the Board of Architects and Engineers website on September 26, 2018, and we are meeting in room 1A of the Davy Crockett Tower. And at this time, I think, if I could find my agenda, I've got it somewhere around here. I will ask for a roll call.
Susan Ballard. Here. Robert Campbell.
Present.
Ricky Bersai.
Here.
Grant Minshew. Blair Parker.
Here.
Brian Tibbs.
Here.
Rick Thompson.
Here.
Frank Wagster.
Here.
Kathy Ware.
Here.
Alton Heathcote.
Above ground, vertical, and present.
Stephen King.
Here.
You have a quorum.
All right, thank you very much, Wanda. And at this time, we have our acknowledgement of our guests, please. Let's start in the back. I see Nathan in a dapper tan suit, so very good. All right. Okay. Perfect. Don, let's just stay on that side. Good. And I think everybody else's staff, I see one new face, maybe.
Chris.
Oh, Chris. I didn't see Chris is over here behind.
Chris Watney, I'm representing ASCE Tennessee.
Perfect. Oh.
If I could, from legal, I'm Tony Glando from the Chief Counsel. I'll introduce you all to Ashley Gino. Ashley Gino is an attorney with our legal division who came to us, I think, in April. Is that correct? March. So she started with us in March, and until recently, she was the disciplinary counsel for the funeral board and the burial services and pre-need. And she also is the attorney who provides all legal advice to the Division of Consumer Affairs for the department. So, and the reason why she's here today is that over the past few weeks, our legal division has gone through and looked at reorganizing our staff. And this week we have a new way that we're splitting up the program. So we have good news, we have some unfortunate news. As of today will be Liz's last meeting with the board. It will also be Sarah Page's last meeting. But Ashley Gino is going to be your new board attorney and disciplinary counsel going forward. So she'll be here for the December meeting going forward. So she's here today to observe. And all of the items that you've given Liz, we've taken note of, and we'll move forward with those for the next meeting. Anybody have any questions of me? And this is a general restructure throughout our legal division for regulatory boards divisions. Our deputy general counsel, previous one, Michael Driver, he took on a different position within the department, which created a gap. And Mark Green was promoted to his job as deputy general counsel. And so, because of that, we've had some other attorneys who have moved upstairs to the insurance division. We've had to look at hiring another attorney, and with that is shifting around some of the workload that we have. So we've had to shift a couple of attorneys, move from some programs, take on other programs, and that's what's necessitated it. And so, unfortunately, I have to tell you all that you're losing your two attorneys that you've had for the past I think few years, and I apologize for that, but it was necessary. But I want you all to know that we are determined to give you all the best legal advice that we can give you within the division. Anything that we can do to get to that, we'll do. And if you have any issues, please, I'm always available to speak with you all about that.
Hey, Tony, hopefully these two fine attorneys are being promoted. They've done a great job for us, is my point.
I appreciate that, and that's one of those joking points. I've been in my position as a supervisor for 4 years, and I make the joke that not many people tell me to drive safely when I go home at night. But they do. Liz and Sarah do absolutely excellent work for us, and they're taking on some some different roles moving forward. So they're keeping some programs are moving around, but unfortunately, neither one are getting promoted at this time because of the changes. We've just had some internal personnel movements that has necessitated us to change the way that we give services to our clients, and we constantly do it. Probably once a year, we start making movements back and forth in order to do that.
Just for my edification, because I'm only 2 years into this and still learning a lot. Is it historical that we've always had 2 attorneys, one for each, or do we go back and forth between one, sharing duties? I just don't know the history.
I have I have a certain number of years of background. You've always generally had a board attorney assigned to you, and I believe when you've had disciplinary matters that have been assigned, that have been brought to you by one attorney, and done it that way. And I believe you've had it where you've had a board attorney who may have actually provided you with the legal report, but there was a different attorney who would litigate that if it came to a formal hearing. That was our model that we had for several years. And our model right now would make it that you would have one attorney that would provide board attorney work, also provide you with the legal report, and then that person would also potentially litigate before this board. However, we do have a pretty good depth of attorneys who can assist us in litigating, and I think this board, if you have complex issues that deal with expert witnesses and whatnot, we don't shy away from putting more than one attorney on a case to bring it to you if it's that important. So I think you've had it both ways before in the past, and we're probably going back to a more traditional way of doing it with this board.
Just, I don't know if this is the proper time, but definitely I hate to see them both go. They've, for the short amount of time we've been on here, I've definitely leaned on them a lot for everything. So it's a disappointment, but I hope that the futures are still growing for them. But definitely hate to see you guys go, and you both have been very supportive of us, especially of us newbies, I'm sure.
Yes, ma'am.
Want to not have a nice comment. I'm very disappointed. In the last 4 years, we have had another set of attorneys every year, and it's hard on us because they have to learn the job over and over and over. And I hate to see them go because I feel like now they're really getting the big picture of what we do. Not hitting you personally, Tony, but it's just hard. We have to leave our jobs. We have to come here and take care of business, and now we got to start all over fresh. No offense to you either. I understand it's a process, but I just don't see that it's in the best interest of this board to keep yanking a different attorney in here every year. And I'll shut up after that. So.
Anybody else? Yes, sir, Rick.
Liz, I hope it wasn't because you were marrying an Auburn man. So, but thank you for all the work you've done. War Eagle.
And I'll say one quick thing. I'll echo some of the things that Susan said. I think one of the things that's difficult about losing attorneys is there's some consistency because of the background information. And Ashley, this is definitely not a slam against you, but there is some learning curve stuff that obviously the law is the law, but there's the law between the lines too that sometimes we have to, and some of that historical information and the debates and the back and forth that hurt. So we'll try to get you up to speed as quickly as possible. If we don't throw things or anything like that, but if we ask the same question 5 or 6 times, it's certainly not just trying to get us all on the same page. So again, I'm disappointed as well. Elizabeth, you've been great. I appreciate everything you've done for the board. You've in some ways we've got to see you kind of grow up before our eyes, so I appreciate that part of it. And Sarah, I've really been very grateful on the way you've handled our discipline cases, the thoroughness you've done, and consistency that you've brought to that process. And again, we hate to have you both go, but Ashley, you're with us now. You're ours, and we're going to make sure that we all succeed together. And I'm confident that we'll be able to do that. So. And Tony, I know you've got a tough job. People move and go, but I will echo Susan's comments. There some consistency seems to be a little better to make sure the trains run on time. And you know, from a business standpoint, which, and some say I have one and run one, some say it's a jungle, so I don't know if that's exactly right. But consistency does make a better model. So anyway, I'll shut up after that unless anybody else got anything to say. Good luck. We're getting married soon. Yeah, so, well, see, that's good. And anyway. we might want to check what's in that cup here in a little bit. So, especially given the logo that's on it. All right. Everything else? Okay, very good. Thank you, sir. Appreciate letting us know on that. And we've acknowledged the guest. Announcements. I've got one quick one, and this is more of a comment. And of course, I'm going to take more time saying it than I'm going to save time, but we've talked about a lot of stuff over the last couple of days. We've got a lot of reports, some a little bit different, more than we normally have. Just make sure we keep our comments on some of those concise and keep things moving. I think we've got, you know, a long enough agenda that I'm not going to set any records today. So, but keep your comments. I want to make sure we have the appropriate amount of discussion, obviously, but let's not plow the same ground multiple times if we can avoid it, because we do have a longer agenda. With that in mind, looking at the agenda for any changes or additions, I'll entertain those at this time.
I don't see the QBS report from the meeting Wednesday afternoon listed on the agenda.
Okay. And I think that's probably a good add. I've looked at it again today. Some people were in that meeting, some were not, and obviously it impacts the entire board. Some of that discussion and what we're doing going forward. So I think a report on that would be satisfactory. Roxana,
Yes, sir.
where do you where would you think would be a good place to put that?
I think with the committee reports, if it's okay with the board, we can put it first thing or we can put it at the end. Anywhere there is perfectly
Yeah,
fine.
let's put it there, but before the interior. Yeah, let's put it first thing. That'd be fine if that's okay with the interior design folks.
Sure.
All right. Deal. That's one of the things we've talked about. That was part of this week and that certainly was a large part of it. Any other changes? Everything's good? All right, well, we'll keep the agenda as it's printed with that change, and I'm sure there's some vote that we need to have, but I don't see anybody objecting to any of that, so we'll keep on going. Okay. Now we've got the minutes from our August 2018 board meeting, and that's on page 5 of your iPads. And let me say one last thing here I think it's on page 5. It is, right? Okay.
Yes.
Roxanne, again, thank you for getting this stuff out on the time you did. That gave me certainly enough time to kind of look through and make sure. And these page numbers on here definitely help a lot in trying to track where we are going back and forth. So I appreciate you getting that to us in a timely manner and kind of giving us something to get us less distracted. As I get older, I do that easier. So I appreciate you doing that. So page 5, our minutes. If everybody's had time, hopefully, to review those.
Chairman, I've reviewed the minutes of the previous meeting, and I move that we approve those.
A second.
Okay, go ahead, Blair. We can have a discussion.
There's one misspelling. On the front page, it refers to Mr. Ballard under minutes. Mr. Ballard, it was a small, minor spelling error, but it would be nice to have that corrected. Sorry.
Well, that's okay.
Amend my motion with the correction that's been brought
Very
forward.
good, and I'm sure the second is.
I
okay
amend
with
my
that.
second.
Very good. Any more discussion? All right, all those in favor say aye.
Aye.
Any opposed? And the ayes have it. All right. Professional society reports. Let's go in opposite. Don, I'll put you on first since you went last in introductions. How's that? Nothing like messing everybody up.
Good morning again. I'm Don Baltimore, representing the Tennessee Interior Design, Education, and Advocacy Association, which represents the interior designers of Tennessee, and we have really not a lot to report. We're not planning at this time to push any major legislation in the upcoming legislature. We're mostly urging our members to participate in the elections, which are upcoming, so and have a voice just like everyone else. And then when the legislature reconvenes, we look forward to working with the board and the other associations on any legislation that arises. As far as activities, the Tennessee chapter of the American Society of Interior Designers is having its state convention this month on the 18th and 19th at Cheekwood, where they will have awards for design projects, commercial projects, and so forth, as well as students. So that's kind of where our activity. Susan. And this also, I forgot to mention, thank you, Susan, yes, very important. This is Interior Design Awareness Month, proclaimed by Governor Haslam as part of the health, safety, and welfare to the Tennessee citizens due to the importance of interior design, other flammable materials, and other aspects of health, safety, and welfare. Thank you.
Very good. Any questions from anybody? All right. Thank you very much, Don. Appreciate it. Casey?
I can't follow Nathan, so as we all know. The engineers had a great conference. It was a joint, in September, joint conference of ACEC, TSPE, ASCE, and TNSEA, which are the structural engineers. We were at Franklin Marriott for 3 days, had 644 people there, which was outstanding and a lot, but it went really well. Lots of really great, 8 different educational tracks with lots of different really great presentations. And I really appreciate Kathy and Robert were speakers on behalf of the board, and we've really appreciated their efforts there. Next year we'll give you a little more time on that agenda. Someone who knows how long we can all talk will submit that perhaps we need longer. We are in the process around the state at TSPE of recognizing the new PEs that came out of the spring exam. As y'all are aware, the certificates, their new PE certificates, come from the board to me, and then I distribute them to the chapters. That's getting to be a more onerous process than you might imagine, because these kids don't stay in the same house for 3 months at a time, apparently, and we moved. So hopefully we will see lots of them in the next month, but those are all happening this week, next week, and the week after. Our PE exam review is close to wrapping up. The test is, you all know, in end of October, so we've got, 3 more weeks of that course, and it's been going really well. We appreciate Chris Gwaltney and the team at Lipscomb, because we've been doing it live streamed from there, so that's great. And October the 26th we are going to do a celebration of the Engineering Excellence Awards and the 50th anniversary of ACEC. We'll be doing that at the Omni downtown Nashville. And if we hadn't been sitting in this room all week, you would have already received an invitation, but hopefully you'll have one at your office on Monday. But would love to see you all there. I think it's going to be a really special, nice event. So any questions?
Just a couple things. We have a former president of ACEC sitting over here to my right, Ms. Ware.
Ms. Ware will be recognized.
Yes, and so that's good. And one other quick thing, the review class, Chris and everybody that's involved in that's very much a worthwhile effort. We've seen a lot of people that take that class have very good success on the PE, and I think that's a wonderful way to promote licensure, is to get them licensed. So
what we're trying to do with it too is, now that we've got the kinks kind of worked out on the remote access, is to open it up. It's been opened up, but to really push people from around the state to be in it, because I think before it was a little bit of a quirky system, and now it's just working beautifully because their technology is so new, and we're in the engineering school using their equipment, and it works really well. So hopefully over time we'll be able to pull more people in, and it is significantly lower in cost than any other option out there. So it's been really good.
Quick follow-up to that, I also appreciate the way that we've teamed with TDOT, because that's been one of their initiatives to get a lot of their engineers licensed, and that provides them with a low-cost alternative, as well as, again, with a great way to have success in passing the test. And I appreciate the way you all have teamed up on that. That's a good private government type partnership thing that's really sowing some good dividends there. So I appreciate that. Anything else?
Robert, I got a question. I had a request, and I think it was from Ryan, but I can't remember. But in the October meeting, when they're handing out the PE certificates, I was asked to attend and do the handing out. Is that okay? I mean, do I need to get permission? Okay, good enough.
So just so that you know, and those of you who might be asked to do it around the state, Hal Balthrop, who used to be on this board, used to do that all the time, and he did a really nice. He would hand them this. Sort of a nicer paper, but just a paper copy of the Engineers Creed, and sort of talk about this, the importance of this role. So if any of you do that, I always thought that was a really sort of hit home with them why he was the one doing it. But thank you for agreeing to do that. Thanks.
All right, Nathan.
Yes, sir.
If we're going to start out with our civics lesson this morning.
Well, we do have a little bit of that, Mr.
Yes,
Chairman.
we do.
And
Sure.
members. But first, a little bit of what I'm actually paid to be here for about the landscape architects. We have a little bit of transition going on. Our new president will take office on October the 22nd, and that's Rebecca Ratz from here in Nashville. She works for our Metropolitan Nashville Parks Department, and we're excited about that. And Erin Tharp of Morristown, she'll still be on our board, but her one-year term has ended. Kate Horton of Memphis will continue to be our executive director, and we're pretty happy about that. Our annual meeting will be in Memphis next year in April the 25th to 26th at the let's see, in our national meeting this year, we got a lot of meetings going. Our national meeting is this month in Philadelphia, the 19th to the 22nd. That group is coming to Nashville in 2021, and we are thrilled about in the civics lesson. Of course, all of y'all are registered to vote, I know, and everybody that works for you is registered to vote, and everybody that you care about is registered to vote, and they're going to go vote. If they're not registered, the last day is the 9th of October. You can do it online now on the at govotn.org or com or something like that. You can find it, and you can also, if you've moved, you can update your registration at that website. So there's really no excuse now, but for some reason, 800,000 Tennesseans who are eligible to vote still are not registered. We are not last, but we're next to last in voter participation. So that's why I preach this all the time. And that leads up to, just like we had this board and all of state government will be having transition time, the legislature is going to undergo a radical transition because 30 House members are walking out the door on November the 6th. So we'll have a lot of new, I call the legislature the state's board of directors for public policy, and the House particularly will have new leadership. They'll have a new speaker and new finance committee chairs, and all the committee chairs might be new for that matter. So be patient with them. Their learning curve will also be very steep. And farewell to our legal beagles, and welcome to the new ones. But seriously, well, I won't wax poetic. People got to go vote. We shouldn't be next to last. I mean, our percentage is.
Nathan, can't hear you.
We shouldn't be next to last in voter participation. Our turnout's like 38-40%. Maine is first, and they're 58%. And the worst years are these midterm elections. And the reason it affects y'all, we're going to have a new governor too, surprise, surprise, and that's the appointing authority for this board and all boards and commissions. So anyway, stay in the game. Y'all, and the reason for y'all, particularly, y'all are thought leaders and opinion leaders in your community. If you send out the email or tell someone at a Rotary Club meeting or something like that, hey, early voting starts on October the 17th, they pay more attention to you. And that's a good thing. So anyway, thank you all for your patience. Happy to respond to any questions, comments.
Thing.
Okay, thank you.
Nathan, I always appreciate those reminders. It helps me to remember.
Thanks, I'm sort of a nerd that way.
No, I do as well, Nathan. I've actually used some of the things that you share with us. I've used them with other people. And
Face-to-face communication is very powerful. I mean, we forget it because we hit the button, hit the return button and send the message out in the ether world that with social media, and I use it sometimes too. But the most powerful communication is still face-to-face. So if the coffee pot in your offices or at the church, between Sunday school and the sermon at church, if you tell folks, they remember that. So anyway, thank y'all.
Thank you very much. All right. We will go on to our legal case report.
Thank you, members of the board. I have a legal report for you today, and just to help clarify, any cases that I have will remain with me, so you can't escape me all the way yet. So anticipate more of my emails and questions, as always. And I will also, Ashley and I share a wall, and she's already become my confidant in many ways, and so she's actually been exposed to some of your casework through being my brain trust. And so we will be here for you all going forward. We're not leaving. We're on the same floor. In fact, soon to be on a very open plan floor where we'll have to look at each other. So we are still here with you in spirit. But to go on, we have a report today and one supplement that I brought. The first case, 2018-046351 and 46151. The first one being an employer, the second being the respondent. This complaint was filed by legal counsel for a state university that indicated a professor had our LinkedIn request from a former student, and then when they accepted it, they noticed that this individual had listed themselves as graduating from the university and a grad program in engineering, and that they were an engineer in training. This professor recalled this student didn't finish the engineering program, and so inquired with the university and learned that not only did she not complete the degree program at this university, she never attended a grad program, obviously, and the years associated were not even years she was enrolled. Additional research on our end revealed that the respondent in multiple publications was holding themselves out as a structural engineer, and other places, other types of engineer, even as so far as to be published as a top 20 under 30 participant for their work in the industry. When I contacted the employer, they were pretty flabbergasted by this. None of the representations were on their website. None of the representation listed that employer. The employer is adamant that this person was a estimator who, yes, worked in CAD and things like that, but ultimately was just doing their basic work to facilitate the real engineers at their firm, and the firm immediately suspended this individual until they could explain themselves, and ultimately she resigned. She responded to the complaint to state that the LinkedIn page had been deleted, but I did ask her to try to address more closely for this board the logic behind using this title in this way, and she said that she didn't know that the title was restricted, but that she also said that if she had known that these publications had used the title without her, used it improperly, she would have told them to take it down, which to me, I just want to present that as a possible credibility problem, which is if you didn't know the title wasn't allowed to be used, then you wouldn't have known to tell a publication not to utilize it. In addition, she copied and pasted one of those publications right into her LinkedIn page, which I had obviously copied before it was deleted. This individual, I think, she's no longer practicing. Everything has been removed that we can find. We've notified as many parties as we can of the misrepresentation. And it does appear the respondent's employer was credible in their lack of knowledge about this representation. So for all of those reasons, I recommend that the complaint against the employer be closed, but as to the respondent, authorize a civil penalty in the amount of $1,000 for improper use of the title engineer without holding a license. So that was a long one, but it's kind of factually interesting. So
questions?
Sir,
Rick was clearing this. Sorry.
I was going to make a motion.
Out of curiosity, when you send a note to an employer or someone about misrepresentation, what exactly is that? That's an email? That's a letter?
in this case, they received received a copy of the complaint itself, and I also emailed them to clarify. In their response to the complaint, they were they said, "Oh, as soon as we receive this, we've removed it." They didn't, and that she is being suspended. The only thing that they were first notified of was the degree discrepancy, and so they suspended her until she could reconcile the records. They wanted to give her a chance to prove she did have this degree, that it was a registrar problem. I contacted them because a lot of these other representations were things I found, and so I contacted them to say, what is her title? What is your understanding of what her role is? They responded to say she's an estimator, this is what her role is, this is who supervises her. And then I responded to say, and provided them where she was representing herself as an engineer to notify them of that representation, because in some places on her Facebook, she did talk about the company. And so the company was not, at that point, by the time this interaction had happened, her employment was already terminated. But I wanted them to know that there was possible public representations that she had been an engineer for them at some point, and they thanked me for that. So that was kind of the sum of our interaction.
Right, Rick.
Chairman, I'd like to make a motion that we accept legal's recommendation.
Good. Do I have a second?
I'll second.
Okay, got a second from Ricky. Any discussion on the matter? Kathy?
I'd like the respondent to receive a cease and desist order for all future use of the title.
Yeah, we'll
in addition,
incorporate that.
Is that in there?
Yeah, we can incorporate that in the consent order.
All right. Anything else? Anybody? All right. All those in favor say aye.
Aye.
Any opposed? The ayes have it. Next, please.
2018-06-0821, a professional engineer. This is a self-reported practicing on an expired license. This individual sealed 2 precast shop drawings after his registration expired. He responded, self-reported immediately when he realized upon renewing in another jurisdiction and checking his registrations that he had expired. So for this one, typical $500 penalty and laws and rules examination.
I'll make a motion to approve staff legal recommendation.
Second.
Second. Is there any discussion? No discussion? All those in favor say aye.
Aye.
Opposed? And the ayes have it. Number 3, please.
2018-052641. This is the same thing, expired license, with a small factual distinction that this individual did not self-report. This individual's firm was absorbed by a new firm, and when they were reviewing it, they realized an old set of plans had been sealed while the individual's seal was expired. In that time, he had not sealed any plans, but was in the middle of a new project. So when the new employer informed him of this, he immediately hired a professional engineer to take over that project and started the renewal process. But he didn't contact us individually. The employer went ahead and did that to cover themselves. But I still list that as their typical $500 and a laws and rules examination.
Chairman, I make a recommendation. We accept the legal recommendation.
Second.
Motion, sorry. Make a motion.
Okay, thank you.
Second.
A second. We got a second over here. Any discussion? Very good. All those in favor say aye.
Aye.
Opposed? Ayes have it.
Number 4, 2018-046661. This is a professional engineer, and Steve King helped me out on this one. I appreciate that. This is a complaint alleging that respondent agreed to do an inspection on a residential home, but that the inspection was not thorough, incomplete, and that the engineer actually never went under the home. The inspection was supposed to be for supports under a floor. The report also noted that the support beam was added under the living room was supported by sorry, I got ahead of myself. So the respondent produced a report saying everything was fine. You know, a very short one. Not a lot of information. Ultimately, a home inspection was conducted. The home inspector noticed the issues under the floor with the supports, and I think it's worth noting specifically the support beam added under the living room was supported by 4x4s, and the inspector noted that they did not appear adequate for the weight and that they are on soil rather than a concrete pad. And additionally, they noted that the beam support under the floor was supported by a steel jack on only one end and is moving freely on the other. So the respondent responded and stated the contractor had hired him for the very limited purpose of observing and reviewing the completed framing of an existing load-bearing wall that was removed in the living room and required LCL framing to support it, but that he was not hired to check the columns and the soil underneath the supports for their stability. We inquired into any sort of measurements, pictures, we've been trying to do more of that. He did not have anything of that nature. I will say we were not able, we wanted to get colored pictures of the home inspector's report. We had a copy, not easiest to see, but that was ultimately never released from the home inspector. They were trying to get permission from the original seller to release that. That hasn't happened. So we can't say too much about whether it's true, but it's a pretty good home inspection report. And beyond the truth of the facts, I think Steve can talk to it. Talking to each other, we felt that this is a violation for health, safety, welfare, because regardless of whether it's true or not, the limit to accept an agreement to do a review that's so limited that really isn't going to be offering any real evidence of a support of something that is stable, something that is safe, in and of itself is a public health and safety welfare. So regardless of the truth of the home inspection report, we felt a standard violation of $750 was appropriate. And Steve, if you have anything that you'd like to add to that from your review, we'd love to hear from you.
The situation is, this is appears to be a single-family home and maybe an older home, and it was decided to remove a load-bearing wall. And it seems that the work was done by the contractor, and the engineer was called in after the fact, and the engineer wrote a letter and stated that the beam was adequate. And he refused to take any responsibility for anything other than the beam. And subsequently, a housing inspector came in and took some pictures that I can't really tell, but there was a statement that there was no effort to make sure that the load was transferred from the beam through a column, through the floor into the ground in some way. And that's why we tried to get better pictures to verify that. But the engineer did respond to some of the correspondence that all he did was the beam. So he admitted that, and I don't think that's, whether the contractor hired him to only do the beam, I think his professional responsibility was to analyze the system, and the beam can't stand up without in some way transferring the load to the ground.
Questions, comments? Yes, sir.
So this seems like a competency issue to me. I mean, if someone asks you what color the traffic light is and you say yellow, well, I mean, that's a pretty straightforward statement, but that does mean caution. And if you don't recognize the fact that there are issues, and, that's just a cop-out. I was only looking at the beam. Well, that's not good enough. That's just not good enough. And I don't know what additional penalties we could apply, but I think this is pretty light for that kind of a response to, it's life safety here.
You can. The range is from 500 to 1,000, so that's an option. I know that you mentioned competency. I think it's important to keep in mind the legal definition of competency is an unfortunately low bar, which is someone does not have the ability to complete the task. And here, my facts indicate he didn't start the task, so that would be a difficult proof problem. But you can increase the penalty to $1,000 for sure for that violation for health, safety, welfare. That's kind of where we went with it.
Do we need to wait till we can get more information, to get the information from the homeowner, the pictures, before we make a decision? And I'm just bringing that up.
I didn't think so, particularly when the engineer admitted that he didn't consider anything other than the beam.
Okay.
Mr. Chairman?
Yes, Frank.
I'd like to move that we authorize a civil penalty in the amount of $1,000 for failure to take the proper consideration of HSW of the public by conducting a partial review of support for the system.
We got a motion.
I would second that.
Very good. Did you have a question? Okay, go ahead.
Just a comment after the motion, that I don't think we're saying, we get asked to look at existing buildings all the time at specific areas, and I don't think we're saying that because somebody walks in a building and is asked to look at this part, they become responsible for the whole building. I think we're saying that in the scope of work, in this case, the scope of work should have included going down beneath to see what this beam was bearing on. So I just wanted to make that distinction, that we're not saying you have to become responsible for a whole building if you're just asked to look at a part of it.
And I think that's really good. I think the entire system, when you look at a beam, you need to see what it's resting on, whether it's a wall or something. So I think that's a good clarification that often we can't see through walls and but the things that we should incorporate in the task we should incorporate. So anyway, yes, sir.
I think the key thing that a engineer should recognize that was explained here is that a wall was removed, and that's the reason that the beam's there. And you don't remove the wall, stick a beam up there, and not support the ends of the beam. I mean,
I tried to do that on a couple of structures tests, and it didn't work out real well for me.
One comment I did have is I noticed I didn't have laws and rules. Would you like to add laws and rules? Yeah, I thought so.
Is that okay with your motion?
Yes,
Okay.
Philip Lim.
Yes.
You're going to
Addition
teach
to
Ashley
the
about
amendment.
that too, right? Okay.
Everyone's got to do the laws and rules. I need to do the laws and rules before I leave.
And pass.
I can do
Take
it.
and pass the law.
All right. Any more discussion? Good discussion on this. Very good. We've got a motion. We've got a second. We've had discussion. So all those in favor say aye.
Aye.
Any opposed? And the ayes have it. Number 5.
Number 5, this is 2018-04-3391 and 2018-04-3411. This is two professional engineers. Robert helped me out on this. Thank you, Robert. This was a complaint from the respondent's former employer. The complaint alleges that respondent discovered that the respondents had planned while working for him to open their own firm. And so it's really a lengthy employment dispute over whether they were loyal to the company, whether they were utilizing their position to acquire client lists, the kinds of things that you would see in an employment law dispute, perhaps a non-compete clause violation, things like that we would see in the employment law realm. This employer pointed to some of our national standards about being loyal and not you abusing your position as possible grounds for discipline. But my review legally indicated that there wasn't a likely statute or rule we could fit this under that we would want to, that this is likely better handled in civil court. But to be sure, I sent it to Robert. So Robert, if you had any additional thoughts about this one, but
I'll hopefully real quick on this. Basically, two guys left a firm that was alleged that they stole documents, standard contract documents, specification documents, etc., and kind of cultivated existing clients to go with them. So there are a lot of allegations that way. On the other side, they said, this firm couldn't get the work done, and that's one of the reasons we left, poor work conditions, etc., etc. Do I think it's unethical? Yes. But our rules don't have anything in them about ethical behavior. Our code of conduct does, but our rules have nothing in there about that. So there was nothing to charge them with from our rules, and Alton and I talked about that a little earlier. So I'm going to have to abstain myself from the vote, but I'll be free to answer any questions on that. Alton.
I've got a real issue with this. I think Robert did the same thing I did. When I read this the first time, I looked through all the rules and regulations, and I thought, surely to goodness there's something in there that requires an engineer to behave ethically. But there's not. And I know this may be you can tell me whether or not it's a violation of protocol. But maybe we want to wait until, if I understand correctly, there's a civil action in place in this case.
I haven't confirmed that, but I definitely can, and we could put it in a litigation monitoring hold to see if an order comes out one way or the other.
I would appreciate the opportunity to do that until we make a decision on this particular issue, and at least, and I don't think we've ever done this before, but can the licensing board send a copy of the canon of ethics and the code of conduct to whoever these respondents are?
We can do it in the form of a letter of instruction, but I would recommend if you want to hold on the litigation, you would do it at the end of that process, because it would close out the case.
I agree too. That would be in addition to whatever other action we would take, but at least that. But I agree that we should wait until after the civil action is complete. I don't have the ability to make a motion to do that.
In response to that, previously, just for the record, we have dismissed these cases because they are a civil case. We cannot make a decision on the right or the wrong. If they actually did that, that's required by a court of law. I'm not sure that I want to go to the point where we put something in somebody's file. So I can't support that position. Just
I think
so
that's
you
what
know.
he's saying, wait till, and Sarah, wait till after any litigation is complete before we take any kind of action.
All right, Sarah, have we done that previously in the past? I mean, I want to make sure we can if we can. I'm not.
We can always put something, especially if we think something's being litigated, more facts can be discovered. To kind of explain the process, we basically put it on a shelf. I have the parties enter into a written agreement with me that says as they proceed through litigation, they'll produce discovery. I have a little hesitation here in that we'll ever get something that would fall under our rules necessarily. This is, I kind of agree with you, there's a little bit of a balancing of resources here. But at the same time, you never know. You know, as these cases go forward, we could get some allegations coming forth in discovery that could possibly imply a board violation. Now at that time, the respondents, the employer, the complainant could file another complaint. But it's also up to you. Very common to put cases in litigation monitoring and watch the cases it pursues, and we just check in. And Jared's excellent at keeping up with it, so it's not uncommon at all.
Thank you.
And before I call on Susan and then Frank, let me say this. I think that's a wise thing to do, and here's why. There is an allegation in here about the theft of a work product. Okay, if that allegation is proven true, then we do have a board rule that allows us to take some sort of action against that. So, again, we don't have the basis or the way to prove that true or false at this time. It's just an allegation. So I think if we kind of put it on its shelf and see what resolution comes from the court system, then maybe we have better information and it matches up with some of our thing, or doesn't. So, Susan.
My question is there an employment agreement between the two people that we could get
There doesn't seem to be a formal contract that I'm aware of, so there could be, but that would be something that it would be produced in discovery for us, which would be great because it's like I don't have to go get it and pay for it. So,
Frank, did you have a question, or did you?
I think you answered it. I was going to ask, okay, we wait and we find a result, what do we do with it?
I think we wait to see what the results are to see if any of those fit our.
And I think you answered the question by saying we do have a rule there, or a list in the penalties of if somebody tries to take away somebody's possessions.
yeah, assisting or abetting improper or illegal conduct for anyone in the connection to a project is possible. Also, possible divulsion of confidential client information. So, there's a couple things that could ultimately tie in here that we do have jurisdiction on.
Felonies are also one of the things, if it rises to that level, that we have the ability to do. So, I mean, we'll have to see. All right, so I think for this time, let's just put that on hold. Do we need a motion to discontinue to monitor that, or is that something that?
Yes, a motion to place this case in litigation monitoring.
So moved.
Second.
Any more discussion? All right. All in favor?
Aye.
Very good.
Number 6, making sure before I go forward, 2018-060781, involving a professional engineer. This is reporting on an expired license. They sealed one project. It was an oversight, and this first lapse he has had, so $500 penalty, laws and rules.
All right. Any discussion? Any motion? Anything?
I'll make a motion that we approve the recommendation.
Second.
Motion second. Is there any discussion? All those in favor say aye.
Aye.
Opposed? Yeah, let's have it.
Number 7, 2018-060681. This is a non-registered individual. The complainants, out-of-state complainants, stated they had paid $600 deposit to get residential plans drafted from respondent. That respondent never produced the plans. Our research indicated respondent is not licensed, but the plans do not require them be registered because it was for a small single-family residence. So unfortunately, while this is an unfortunate situation, these complainants' avenue for relief is civil court. So they will need to pursue it there. So for that reason, I recommended closure for lack of jurisdiction.
Okay. Like a motion?
Make a motion to follow legal's recommendation.
Second. All right. Any discussion? All those in favor say aye.
Aye.
Those opposed? Ayes have it.
Number 8, 2017-01-8981 and 1921. There is an omission. I will have you know, Mr. King, I've added on mine, so we'll be in the minutes. Mr. King did help me review this. He's not listed, and he deserves credit for this because he's spent some time on it. This is the case you maybe remember a little bit of where we had a landscape, a land surveyor and a professional engineer involved in a project with sealing, having a number of issues. In some, the very first set of drawings that were sent to a codes department only contained the land surveyor's seal on multiple pages, and some of those pages included some engineering work, including retention walls, things like that. And ultimately, the engineer's seal was only on the calculations page. Later, they did remedy that. They went back and they sealed. On some pages, they both sealed. On others, it was just the surveyor. They didn't delegate which work they did, but they indicated that they had both worked on the pages they sealed, and that's why there were duplicate seals. Ultimately, we brought this because of the land surveyor not only sealing the plans, but indicating some of the work he performed in his response. We deferred this matter to the land surveyor's board for them to take action in regard to the land surveyor. They ultimately closed their matter on a letter of instruction, one of those about not going outside of your realm of expertise and sealing requirements that the land surveyors also have. I brought that back to you all because the complaint that we had originally was only against the surveyor. I think wisely this board opted to hold those matters, reopen against the surveyor and the engineer to allow the engineer to explain the supervision role, what the scope of their work was, how they seal documents. What we were able to discover is the land surveyor and the engineer own this firm together. They do the work together to a large extent, each with their own in their own area of expertise. They still hold that the sealing errors were an error in a rush to get plans in on time, and that they have corrected them, and the project has been approved and everything has moved forward. The engineer wisely picked up that we were curious about why they didn't delegate which parts of each set of plans were theirs. He made an argument that if you look at the rule, it says that if there were a question of work, you would write it out, and at that point there hadn't been a question, and that he did the engineering and his partner did the surveying. I leave that to you on how credible that is, but the language is in there. You know, I'll give them that a little bit, but ultimately they both have remedied the project. And I let Steve look at this one just to make sure on everything. And Steve, do you have anything you want to talk about on this one?
Well, of course, you may remember my discussion about the land surveyor originally, and when we sent it on to the surveyor's board. But what bothered me about the engineer's response, he never even offered an explanation as to why the drawings were let out of the office originally with only the land surveyor's stamp on all the sheets. So that bothered me. He wanted to argue about, well, it was obvious what was engineering and what was land surveying. Well, obviously it wasn't when he let the drawings out of his office with only the land surveyor's stamp on it. So that bothered me. So, but then at the same time, I really didn't feel like we should do more to the engineer than we are willing, or the surveyor's board was willing to do to the land surveyor. That's the part that there could be some disagreement on with the board as we discuss this, but so I think we ended up with a recommendation for was it
letters
a letter
of warnings for both parties, but the engineer to take the laws and rules examination, which in some ways is in line with our some of the actions we've taken with seals lately. A first sealing error. Obviously, this one ended up being a little bit of a bigger catastrophe, but they did remedy it. So it's not out of line with what we've done before, but I agree. Steve and I kind of talked back and forth on how we wanted to handle it in light of the other board taking action, and really the surveyor kind of being the lead on some of the misconduct, if you will, with the engineer being more passive or not involved until the error occurred and coming into remedy. So.
Question? Yes, ma'am.
Just a quick question for Steve. Were there any apparent errors, or was there anything that was substantive with regard to mistakes?
No, I don't think so. There was a detention pond, and those calculations were stamped by the engineer. I don't think there was any. The work seemed to be appropriate. The problem was just who was going to certify which work.
But there wasn't any risk to the public or necessarily to the client relative to getting an improper work product?
No.
Okay, thank you.
Anybody else?
I do have a question. Is the client aware of this problem?
Yes, because the codes department rejected the first set of plans because they have the common ordinance that you must have an engineer or an architect on there, so they are aware.
And did you ever speak with the client?
No, this was sent over by the fire marshal's office,
Okay.
I believe.
All right.
I think it was sent by the city engineer of the
Oh,
town.
that's right, yes. This is a local project. Thanks,
Yes.
Steve.
Go ahead.
Steve, do you get a sense of whether is a letter of warning enough that you'd think that they would pay attention to this kind of thing? Because I think what happened was the first time they put out the plans, the land surveyor incorrectly stamped everything, whether it was an oversight or intentional or convenience or whatever. Do you get a sense that this won't happen again with a letter of warning?
I think that they will get the point. It does bother me. I'm concerned that they're just in reading their responses, it seems there's some disregard for what is engineering and what is land surveying, and they work together. So it's almost like they leave it up to the discretion of the reviewing agency. Well, that's not proper. I know there may be some gray areas where local government says, I want this person to stamp this work, in some of the overlap areas, but some of these things were very clear. The grading plan and the details for the detention pond. There was a small retaining wall that was all this was originally stamped by the surveyor. So it just shows that there was some confusion there, and the engineer did note in his response that he had never had a complaint filed on him, and I think they will both get the point. But I could also understand why there's some feeling that maybe we ought to do a little more, but we don't have I don't know that we have the ability to do that to the surveyor, and that's what I struggled with.
All right, any more discussion, motion, or anything? Rick wants to make a motion, I can tell.
Make a motion that we accept legal's recommendation.
Second. Any more discussion? All those in favor say aye.
Aye.
Any opposed? All right, the ayes have it. The last one is this, right?
That's right. So we have a
Okay.
supplemental one. We are waiting on some additional responses from our respondent. He provided quite thorough work when I asked questions, so it took a little while. 2018-030541 involving a professional engineer. There's a history here, which is uncommon, but it wasn't too bad. It's just a letter of caution over improper use of electronic seals during this individual's transition from using a stamp to the electronic seal. So nothing too noteworthy. I had two fantastic helpers on this. I appreciate both of you. Ricky took a look at it first, and then Alton took a look at it second. I thank you both very much. This case, a respondent was hired by the complainant, which is a pastor of a church, to produce civil site plans. The pastor filed the complaint alleging the plans did not fit the church's needs and stated that the contracts used were not an AIA form and that they had general issues and weren't able to use the plans produced for them. The pastor, through responses, pointed particularly at the inclusion of a retention pond that ultimately became in dispute on if it was necessary or not. Respondent responded in detail, indicating that that he had worked with them for a year and that the plan was originally under an acre, and that after a year of site plan, they decided to pretty drastically increase the size of the site that they wanted plans for, and that he had worked with them, and the respondent indicated he didn't even realize there was really too many issues going on until the complaint came in, and that he'd actually never really talked with this pastor before. The plans and process were both reviewed, and I want to turn it more over to them since it's about, I think the kind of had three issues. Does it matter that the contracts were in AIA form? I think we all decided no. Whether the respondent properly, was professional with their client and addressed the scope of needs and did what they needed to, and then also really this retention pond as a particular issue. Is that something that shouldn't have been included? Was it something that would rise to the level of a lack of competence? What was the issue there? So, Ricky, I don't know if you want to start with your initial review, and then we can turn to Alton for the more detail from his side of you.
Sure. When I reviewed it, it looked to me that the engineer's responses about the actions that they took were all very reasonable and professional, and had an answer that satisfied me on all of the questions and points that were raised. But I suggested that since it was exactly what Alton does, that we bring in, I mean, it's like having a thoroughbred, not running him in a race, is what I'm saying. So get the thoroughbred to talk.
This is a fairly, to me, a fairly simple matter. We seem to get a lot of church complaints. In this particular instance, the engineer did not use an AIA form, but he did, it's not required, he did give the complainant a very detailed scope of services and a proposal for his work, outlining very specifically all of the elements that he was going to provide, and it required some further questions. We were able to ask further questions to get evidence that he in fact did provide all of those elements of his scope of services, including all of the permit approvals that he could obtain from the authority having jurisdiction. There were some permits that weren't obtained, but those were the complainant's responsibility, like submittal of a metal building information, hiring a licensed contractor, and things of that nature, that the respondent had no responsibility and was not part of his scope. So in our opinion, the respondent performed his services in accordance with his scope, even reviewed the requirements associated with the detention pond, looked at the calculations which he provided, and they were competently prepared.
All right. Any questions, comments?
Just a reminder, too, for my reviewers to recuse themselves. That's all. I should have said that at the beginning. Sorry, everybody.
Okay, we got a motion. Do we have a second?
Second.
A second. Any more discussion? All those in favor say aye.
Aye.
Those opposed?
This respondent did want me to relay a message. I told him I would, that he thanks you for your time and is always happy to defend the quality of his work, and that he appreciates the work this board did. So I let him know that I would relay that message to you, but I wanted to wait till you had considered his case. So with that, thank you. This is my last legal report with you all, but I will still be litigating and be around. Please never hesitate to contact me if I can be of any help, if there's anything you need really in any aspects. And it's been, it's been a pleasure working with you.
I particularly want to thank Sarah. You are extremely competent at what you do and very, very thorough. And your response to requests that we ask of you is immediate and thorough and very well presented. And I'm awfully grateful for the chance of having worked with you. So thank you very much for everything that you've done for this board.
Larry?
Sarah, I'll offer the same comment. For me, it's wonderful that you understand what we're looking for. So in your presentation and the written material and what have you, typically most of the questions are already answered for me. So thank you very much.
We're going to miss you both. So.
All right, and I'll echo all that too. No, wait, whoa, I've got Steve King.
I wanted to say, echo the same thing, but in addition, I wanted to say that I've worked with a lot of attorneys through the years in my work with the city of Knoxville and defending situations where the city sued. And one of the common things I've always found with attorneys, they don't like to listen to engineers. And sometimes we have things that need to be heard, and I appreciate you listening. Thank you.
Catherine?
I'd just like to go on the record as saying that if there has been a reorganization within the department and they have failed to see the opportunity to promote you, then that is a failing of the leadership, and I hope that they will rectify that soon. You are more than worthy. I wish you all the best, and I'm sure that it will happen soon for you.
All right, whoa, we got one more. It sounds to me like we got a bunch of people that think they're going to be in prison one of these days. Go ahead, Richard.
Sarah, it's been an absolute pleasure to work with you on reviewing these cases. So, wonderful.
Anybody else? Brian, did you have your... You were going to second the being in prison part. Okay.
I got you. Don't worry. Pro bono.
All right. Again, thank you very much, Sarah, for your efforts. This board appreciates it, and the registrants from the state of Tennessee that we represent definitely do too. It's how we kind of keep the barbarians at the gate. I appreciate that. So thank you.
Thank you.
All right. Next items, and I'll get back to my agenda one of these days. We are on director's report.
Thank you. Okay, I believe we start with the complaints data that is on page 19 of your iPads. I'll kind of walk you through the reports. These were sent in advance, and so hopefully if we had anything extra that you wanted, I didn't hear from anybody else, so I'm hoping that this at least gives us a basic view of what the reports look like. And I want to start with good news, which is our system is almost live with Tableau reports. That means we're going to be able to have some kind of good-looking, robust reports that I can even put online for our registrants to properly, as we discussed, and I know Kathy brought this up, really protect the public by listing these things out there. So right now, this is still the view of the report, but hopefully in the next couple of months, I'll be able to protect that, and you'll see them on our meeting reports every time, but we'll also publish them. The first one that you have is for 2017. So I had to kind of squeeze columns and do some maneuvering so that it would fit on one page and you could look at it. Starts with profession 1201, which is our architects. Beginning, opening date, closing date. The summary is pretty much us typing in a narrative, an explanation of what the case is about. And then the source, I think, is that last column that's very important. That lets us know if it's coming from a consumer, if it's coming internally, if it's an administrative complaint. That would be us opening it many times for continuing education kind of things. So 2017 ended up with 71 cases, and I don't want to say that is the final total. I believe it is, but I did a lot of moving at the last minute of 2017, and you've got all the professions there. 1202 is our engineers, 1203 is one landscape architect is somewhere there, and then the firms are 1204 and 1205. So another thing that'll be nice on the other report is it'll hopefully say the name of the profession and not this hidden code that needs to be interpreted. So 2017 had 71 complaints total, and I'm showing you the closed ones. Obviously, the open ones are still back and forth, so to give you some history behind that. And then you start on the 2018 report so far on page 26, and that's as of the end of August. The September cases are not there. Again, the profession codes are listed for you. But what I did want you to know, that ends with 86 cases, and one of the big reasons for the increase in cases, even though we don't have a full 12 months, is the complaint process, I think we discussed, is now going through a centralized team, and that team opens every complaint. So where before maybe some that were outside of our jurisdiction might not have been opened, the thought is if it comes into the division, the only way to know that there's a pattern or properly deal with these things is to open all of them. We can close it later, but that means your numbers are going to be a little bit higher. So questions, and I know that I haven't presented them this way. This may be exactly what you're used to looking for from John. I'm not sure, but they're going to change slightly to where I think you will like the new vision of the reports, and then that's what we're going to publish online.
Yes, I'm a little surprised to see names.
Yeah.
You know, we're careful
Right.
when we.
These are closed, so once
So
they're
that- that's
closed,
the
they
difference?
become
Okay.
yes.
Okay.
This is part of the disciplinary action report. So I think when we discussed the newsletter, for example, going away, the question was good. It was how do we then properly protect the public if we can't say what engineer has issues? So if you go out to the main Commerce and Insurance site and look at the disciplinary action report, we have to report it every month. Once it's closed, it is public information. And so that's what these are. What we don't share, same thing with the cases that Sarah just presented. If it's still in the beginning process, then even to you all, those names are not out there yet. Yes, you're welcome.
Ms. Blair.
Just one question. If a complaint comes in from, let's say, a municipality, someone reviewing the plans, I'm assuming that is the referral from an outside agency?
Yes, it would be a referral from an outside
Right
agency, and
column.
depending, it could be a consumer.
Right, okay.
Yes.
I will make one quick comment. One of the things that I don't see here that I think is helpful for us, was for me, is on it's just a summary, Roxanna, not necessarily, I mean, this information's good, and if it's easy to get to, that's fine. But I think we had kind of a little summary sheet that showed just the case number, how long that we're not closed yet, and kind of gave our percentage at the bottom. And I'm trying to remember if anybody else remembers that report. But
I remember that too.
yeah,
I like
and it was
seeing that
just
also.
it was just a single page.
Without the listing of the cases.
It had the case numbers, I think, but no detail behind it. But it just says this case is pending legal. It had a little comment like pending legal review, and I'll try to go, if I can find one in my old books, I'll try to find one. But and at the bottom of it, it said number of cases with clock stopping action, and then percentage of completion, because that's a metric I think our board's measured on. And if it's a metric, I think we would like to see kind of what that detail is behind it. Me personally, I don't know that I need, if this is going to be on the website or have people have access to it, I'm perfectly fine with it staying on the website and not something that we need to bother with every meeting. But if we're going to be measured on something, I would like to see that, and it had like we were at 97% or something, and our goal was
Also had the
80%.
time frames that they were disposed of, and there was
Yeah.
some measuring stick that the state had established for disposing of cases.
And so on what we call the quarterly complaint report, I have that metric, but as a grand total without the list of the complaints. But, and part of that is because complaints are done by one central area, but I believe we can get it. If you're wanting to still see the case number.
But I think, and
we
because
can
it had detail about, it just had like a one line, it would say, waiting on respondent to get back or
Status, the status of
yeah,
it.
and it was of all the ones that were still open, so that we could kind of get a feel for, do we have 10 of them that may be litigated, or are we just talking about?
I know which report you're talking about. I got you.
That was a pretty helpful report, just to kind of look at it, and again, it was just a brief scan to say, okay, yeah, we're in pretty good shape, or heck, we've got 7 cases, because at one time, and again, this is historical, at one time we had a bunch stacked up out there that we needed to kind of prod everything to get moving so that they didn't jam up the process, and that motivated us to get a few things situated. So if we could kind of see, again, if we're going to be measured on it, I'd like to see what the number is.
I know exactly which report you're talking
Okay.
about as soon as you said something that triggered.
Okay, well,
So, thank you.
and if you have trouble, let me
No,
know.
no.
I've got copies of it, I'm sure, in my old folders. Okay?
Perfect.
Does that sound reasonable, everybody? Okay. All right, thank you very much.
Absolutely. On page 39, you have those that we open internally, and this is just a running tab for 2018. The August, most of them are since our August meeting, and so, and on these, you're not seeing the individuals, it's the closure report, and we do need a motion on that, and these are the ones that we do send a letter of caution automatically, and the board has voted that we can close those right after the meetings. And what we do so that they don't age is knowing that these are the ones we're opening internally. Once the letter goes out, we can close it, and then on the record, we just approve that these are our administrative complaints and move forward.
I have a motion for that.
I'll make a motion that we cases with the letter of caution that are listed here.
Okay. Second. Okay. Any discussion? All right. All in favor say aye.
Aye.
Those opposed? The ayes have it. Okay. Thank you.
Thank you. The next item is the licensing data. I am hoping that maybe some of this will be easier through Tableau as well, but I know I hadn't updated you in a while, and we want to add this back to all of our board meetings. So September 17th is the last date that I was able to run licensing numbers. I'm going to try to keep the 2016 date there and kind of keep some historical content, but not overloaded. And if it's okay with the board, the architects, engineers, landscape architect, interior designers, those professions are fairly easy for me to update every single time, and I think those are the ones that we're mostly concerned with for every meeting. The firms themselves, if we want to update a couple times a year, however you see it, those are more time consuming because there's so many ranks within each firm, if that makes sense to you, that they can come in under. And they don't vary a lot.
Yeah, I think the number of registrants is really the key thing that we're looking for, because that kind of helps us see if there's a potential resource issue that, you know, if we all of a sudden are picking up 1,000 every year, then that gives us some indication of things coming up. So does that sound legitimate? Okay. Well, I mean,
At the last meeting, I think you all wanted it at every meeting, and so
I think if we could do it whichever.
for the registrants, that works fine. That's
that
not,
would be good, just to kind of keep a rolling
Right,
tally on that.
right,
That's fine.
right.
Susan?
We don't have to look at this at this moment, but after the meeting, we've dropped 15 members in 2 months that we actually had gained, had some momentum. So I'm just kind of curious if y'all can let me know who did not renew or should have renewed.
Are we talking about interior designers?
Yes, I'm sorry.
Yeah. This includes those that are in a grace period. So it would be anybody that decides to retire, that they wouldn't count anymore.
So what I had asked for in the past was to let me know, since we are so close on our numbers all the time. So if they've moved, if they've forgotten, you know, we can give them a nice nudge, you know. I can send them an email, something. So anyway, for the first time, we had gained 20 new registrants, and now we've dropped 15 since the last meeting. I'm just concerned.
So quick question. So the last time I think I added numbers were in April. Are you comparing April to now, and those are the ones you're running?
No, it's probably June, because I was talking about it over the summer at some of our gatherings. So, and August was probably another one of them. So anyway.
It would be June. I know I didn't update in August.
Okay.
The last time we updated to now, you want the list of whoever's come off, and it'll be added and subtracted.
Yes, please.
Okay.
Roxana, could you put a date on these forms, just so we don't get them confused?
Oh, absolutely. And this one literally is the 17th. That's why I dated that particular number. I was trying to come up close to the 2017 date for you. So each time it'll probably be a week or two before the meeting, and then I'll date them at the bottom. Absolutely.
Very good. Thank you very much. That's good information to have and be able to see where we are. Financial data.
Financial data, and we discussed this with the financial committee as well. We still do not have the closing of 2018 fiscal year, but you've got just about the last numbers for the expenses and revenues for the year. And so I'm sure by November we'll have the one that kind of gives you the 3 past years and our running total of our surplus at the bottom. This reflects the $248,548 that we have as of the last date on this report, but I think it's going to be pretty current to what we're closing with. So that is everything for revenues and expenses. And then the first month for July has been closed, and that shows us at a surplus of $80,192.
That would have comprehended the fee reduction that we
The
had.
fee reduction had an odd turn of events because, and I think we talked about that rule kind of going back and forth, so some of those folks are actually getting a refund. It didn't get posted and taken off as
Okay.
fast as I would have liked, and I'll take full blame on that. It
fine.
just didn't take place. But it will, as of August and September, not have. It's a small amount,
Right, right.
$15, but nevertheless, that will be in there, yes.
Okay, thank you.
Absolutely.
Blair?
I'm sure, obviously, these numbers can't be in this information, but I'm curious how much we're saving by having our retreat here as opposed to somewhere else.
We will definitely know that, hopefully by the end of, or middle of November, end of November's numbers, we'll be able to compare. It's a comparison to 2 years ago, but I think we will have saved quite a bit, just from office staff even, not needing to go anywhere. So I will put that as an item you'd like to know, what the savings was versus here. One of the items that you had on the 2016 retreat, and I think last year as well, is the travel and speakers that you would like. So that's open really, even though it's listed on my items, for you to bring up so that if there's anything that we need to look in advance to get approved, this would be the time to go over any of those that you want to see discussed.
Susan?
I have not received anything in writing about the NCIDQ meeting in November. We approved it. My travel was approved by the board in August, but I have not gotten anything in writing that's been approved. And I'm the host because it's the national meetings here. So I should go.
I will look at that justification memo, and as soon as I know it's been signed, we'll email you so
Okay.
that you're not booking things in advance. That should be by now done.
Thing, just as a blanket, real quick, I know there'll be presentation of certificates. I'll probably do the one at Knoxville. I'm sure if they have one in Memphis. Just, again, it's not really a travel issue for us. It's just letting the board know that we're going to be doing that. So we're not.
I'm looking through the numbers, and Roxana, please don't think that this is directed at you. This is not. It's just a commentary for the board. And I'd like it to be reflected in the minutes for next meeting, that I think we need to monitor the growth in numbers of registrants, the growth in numbers of registered firms, the number of cases that come before the board, the revenue increases, and what we're doing to save money, because it feels like we're getting, and just population growth for the state of Tennessee. The economy is booming, I mean, still. I'm just concerned. Is anybody else concerned relative to the level of support to protect the public? It seems like we're structuring less and less support, while at the same time the responsibilities to protect the public are growing. Maybe it's just me, but I don't want to lose sight of the fact that a lot of our data indicates upward growth and responsibility, while at the same time we're going from 2 attorneys to 1 attorney. And Roxanne, I know you're working like a dog trying to take care of us, and you got other boards you got to support, and I'm just concerned about that. And so I'd like that to be reflected in the minutes.
Okay. Anything else?
I'd like to support what Kathy's saying. I think that, we've gained over 1,000, new members across the board.
It's a 5% year over year based on the data that she just gave us.
Speaking as a woman who works herself to death all the time, it's real easy to get caught up in that because you want to be the Wonder Woman, and I'm just concerned that our staff is getting pushed too far. So that's all I'm going to say.
Anything else? And I'll make a quick comment. And that's the reason I think we need the data to look at that. And that was in my original comment, was in order to look at the data, to make sure that we are not getting squeezed on support and being able to be responsive to what our registrants need from us and from the staff and everything. I think those numbers definitely give us a pretty good edge in seeing that. And I'll echo the comments. We're seeing a population increase going forward, and more engineers and more complicated items keep coming up. So we need to make sure we're doing our job to protect the health, safety, and welfare. Okay, Alton, this is going to be a real short one. Okay, good.
Do we have information on how many members other boards have and how many you're spread out amongst? Like how many registrants are there on the cosmetology?
Oh.
Not boards, I'm sorry, registrants for or real estate or whatever other boards you're.
I do, and we do, and we can run them. Do you mean?
I'd just like to, just for our own
Comparison.
edification and comparison, to see how we compare.
So landscape architects is roughly at 1,100. Cosmetologists have about 69,000 between business licensed schools and individuals. So it's one of the largest programs. It's one of mine too as well. And in between, we've got 487 court reporters. Appraisers is at 2,300. It's one of our programs. So I think within regulatory boards, we have 260,000 licenses. And I would say we're at 23,000, give or take, when you look at the firms and the architects and engineers.
10%.
Now, yeah, we have about 120,000 of those under mine programs. A little bit more, maybe. That's sort of what your question was?
Yes, ma'am. And a testament to the fact that you're overworked.
We appreciate everything you do.
We do. That's, again, I think our job is to be a fiduciary to make sure that the numbers and everything are lining up with where we are to get the appropriate amount of resources, because to protect the health, safety, and welfare is something we hold pretty seriously. So, good comments. Are you going to make another comment?
Oh, sorry.
All right. Good deal. Oh, you were the one over there for a minute ago. Now you're going to make a comment. Okay.
I was waking up. No, I'm just kidding.
Okay. Good.
I just wanted to caution everyone about just sheer numbers. You know, I'm not saying anything negative about anyone's profession, but some of these professions aren't HSW, okay? And you know, what do you, I don't know what your complaint process is in some of these, and what can you do that's so bad. I won't mention.
Rick, have you never had a bad haircut?
Well, see, I wasn't going to go there, Kathy, but yes.
And we can't make that right?
Yeah.
However, if you get lice or, heaven forbid,
a bad coloring job.
No, the coloring is not my problem. It's not my problem. But you can get some very bad.
I understand. But you know, numbers skew things. I just want to be careful, not, you know, because there's 69,000 versus, that's not quite the same thing. So, thank you.
In the interest of, that was part of another deeper dive, but in the interest of time, I didn't go into all that detail or ask those questions. But obviously, that ought to be a consideration when I guess, Commerce and Insurance is talking about assignment of personnel and staff to this organization. Consideration ought to be given to the complexity and the fact that it is HSW and the, I guess, magnitude, not just the numbers, but the magnitude of the things that we do.
Again, I think having the information, we can at least have the discussion, and having the discussion lets us look at the things we need to look at. Correct. I'm not going to say anything. Mine's going away too, Rick, so I'm not going to say anything. All right. So did we ever finish authorization of travel and speakers, or did we go backwards 3 steps? I'm
We
not
did
doing a real
not.
good job of keeping the train moving in the positive
We've already
direction.
approved mine, but no one else has brought up if they have
Okay,
additional
so we need to
travel.
get you a letter.
We need to find out if it's going to be approved, and I hope it is.
Okay, need to get you a letter. And does anybody else have any authorization of travel and speakers that we need to do anything with? Good? Okay, very good. So I don't know that we even need to make a motion. It's just more information that we'll be handing out some certificates, and there's really no travel or anything involved there. Okay. 2019's proposed travel.
And this may be too early if we don't already know when each of our organizations is doing their meeting. We know August is always NCWES. We know NCARB is doing theirs in Nashville, and so we're going to work real hard to take part of that and be involved somehow. Any other dates that I should look out for, start looking into?
The only one, and this is, I know you all have zone meetings, the architects still have, so we'll have the zone meeting in April or so, I think. And Roxanna, how long has it taken to get authorization? Is that a month process, 2-month process?
A couple of month process.
So
Now,
we probably definitely in December need to look at some of those
Absolutely.
interim meetings that would happen in the spring. And I don't know who else has got what coming up, but
NCARB has their regional.
Frank, I'm sorry, I can't hear you. Oh.
The NCARB usually has their regional meetings in March, and I was just fixing to look because I think I have those dates. And it's in Nashville. They have their annual meeting normally in June, and I'll look that up. And it will be in Washington, D.C. this year. And now
There's also a CLARB meeting, in, I believe, the last weekend in September. I'll check that date. And maybe if we can come back on December and we're all sort of searching for these things. If we come back on December,
I think that
be
should give us
prepared.
plenty of time, with the exception of Susan's that should be already in the pipes, and I'll email her directly with the confirmation and the documentation. But those for 2019, any that you know you want to attend, we can't approve travel outside the United States, but that way we can start moving on those.
I would like to make one statement in regard to our NCARB meeting here in March. We're celebrating the 100th anniversary of NCARB, which was started in Nashville, Tennessee. So it's a little bragging rights there. So anyway, that's all.
oh, that's good. That's good information. Yeah. So, so I'm going to make an assignment. Ricky, since you're over the engineering committee, can you send Roxanna those dates of the zone meetings, and whoever's over the architect committee, Rick, if you'll send the same, and Blair, you are the landscape architect, and Susan the same thing. If you all can be responsible for sending her those dates to make sure that we have everything that you think. And I think in December, let's kind of go through that a little bit more and make sure where we are, so that we don't, I mean, she's not having to go look up stuff that we may or may not know that we're going to, or things that we may have. Grant, we'll have a public member or something or another. I'll put you in charge of it. If it makes you feel better about things, I'll put you in charge of the public member something. So,
My assignment.
Yeah, your assignment is to, I don't know. I'll have to think about that for a little while. But I'll come up with one.
And that'll give us a chance, since obviously our new attorney is new to this, so that she can go to those that are important, and we may have to pick and choose which ones she can go to and which ones I can. But that way we'll be sure to put them in early.
Before you say anything, Susan, I would like, since the NCARB is the 100 and it's in Nashville and some of the significance there, and I know you are going to be there as representatives of the board. Now, it's not that I want to be there necessarily, but I think we need to have something from the A&E board that says, whether it's a proclamation or whether it's a physical, whatever, I don't know. But if we can talk about that in December as well. I mean, I think that's a big deal for our profession in our state. Yes, ma'am.
Typically, John has gone. He couldn't go last year. So does that mean you're going with me to the meeting?
That's the reason we really do want those dates early. You mean in November?
Yes.
I know in November I can't go.
Okay.
It is
Ashley, are
just
you going?
I believe
It's here
the
in town.
justification is only for you, but I will check now
We
that
have-
we've got an attorney to make sure that.
Well, we
can-
have an alternate that's allowed
Yeah.
to go as well. So Rick went last year. Nobody has to go.
Right.
You know, but if something
It'd be
were
great.
happened to me and they were voting, and we wouldn't have anybody there. So, okay, just clarification.
Yes, Rick.
It is good intel for the architects to find out what they're up to, so.
I will say we're doing an office renovation, so I've done pretty much all the colors and carpets I've cared to be around, so I don't want to be the alternate. All right, good discussion. Thank you all, but if you all will forward those, please, so that we can have that discussion in December. And again, make sure that Roxana didn't have to go Google all of our acronyms through the thing. All right, application exam deadline dates.
I have got them here from Wanda, so this is for our engineering exams, and she's got the exam for April is due December 1st. Does that sound right?
Yes.
Okay, and then the October exam, June 15th. These dates are updated on the website, so we will make sure that we've got everything in there. So for 2018, NCWS disciplines for SC, all that information is also posted on our website, and we've got all the way through 2022 posted online. If a link to that is ever asked from you all, or you need anything like that, looking way ahead for the universities, that may be something that on the thank you note I send them a link to, just in case they don't have these deadlines.
So we probably have, let's see, if the test is, did you say December?
December 1st.
So we've got another month probably of applications, don't we?
Yes, that should be increasing.
Okay.
And we had hoped, Wanda has worked really hard, Wanda Phillips that handles the engineering pieces, with our IT folks, we had really hoped to be able to change some things in our technology so that when they pass that exam, they can go online and finish the process for the PE, because these are applicants that have already passed the FE, they're in our system. It's a quirky process for that second piece, and we haven't gotten it fixed. The vendor's very aware of our urgent need to get that piece fixed so that applicants can find themselves, and continue. We're still working on that. Okay. Thank you. And with that, I think that is my last piece, at least for now. So I will turn it over to the committees if the board wants to continue, or you want to take a quick break.
Yeah, I think we're go ahead, Blair, real quick.
Add one item.
Yes.
Wanda mentioned this morning that regarding landscape architecture, those taking the exam, that they now can go directly to CLARB. Matter of fact, they have to go to CLARB and take the exam and go through that process, and then once they're through the CLARB system, then they come to the state of Tennessee. So that is helpful to applicants, that is helpful to staff. It's a wonderful thing to be at this moment.
And I think we'll put something on the website, just bold, because it's something that we just realized went live as well. So
let's do that. Let's take about a 10-minute break, and that gets us to, I think we're starting on I think we moved QBS into this slot here for committee reports, and then we'll go through our normal committee reports. Try to wind this up. So let's try to get, well, it's a little bit more than 10. Let's try to get here quarter till, please. It gives us 12 minutes.
That's a great double top secret.
Very good. All right. Thank you. All right. So we're back from a little bit of a break, and we added an item to our agenda earlier, QBS under committee reports. Let's see. I don't know. I will try my best. I was in the meeting. There were others, and to try to say where we are and what we need to do and all that kind of stuff. We had a QBS meeting yesterday. We basically went through an MTask document that we had. The MTask document, we basically redlined it through in our meeting. I think there was some confusion from our members that was going to be done by a little subgroup or something prior to that meeting. So that didn't quite get taken care of, but we were able to do it then. My understanding is that in talking to Carter after the meeting, he was going to have our changes in a red line document that we were going to send out soon, I hope, and that's a question to ask. And then we're having another meeting, I think it's on December the 6th. It'll be the afternoon of our next board meeting, if that's right. I believe that's right. I don't have my calendar here in front of me. But I think there was some good discussion overall. I think there was some disappointment maybe from some of the people that I talked to that we didn't have a more finished product ready to go forward, and that the lack of participation maybe of the group or lack of attendance at the group, because again, I think there were some issues with maybe some communication on times or who was supposed to be attending. There was also a comment that I received either before, during, or after, and I apologize for not having all my notes here in front of me, about we talked yesterday in the meeting about getting the FAQs possibly added as either an appendix to that document or possibly having those added back to the website, because I think there was some understanding that those would be added back while we were going through this process, and it does seem to be taking longer than our registrants need to be sitting out there without guidance. So I know we've got the one statement on the website, but it's a fairly mom and pop type statement. So anyway, so a couple comments to get back. We would like to have some timelines on when the revised document is, when we're supposed to get things back, and maybe even if there needs to be an interim meeting, that would be okay as well. But we need to get this thing knocked out by December and not carry something into another year. I mean, it's been going on a pretty good period of time now. That's, again, the comments I heard from others during, before, after, whatever, the meeting that we had yesterday. So that's my sort of summary. So Alton, I'll shut up and let you talk.
Roxanna, what is the process and what is the status of having the FAQs returned to the website?
So as far as I know right now, they're not approved to be put back out there. I think, I don't know if before the document is complete they'll be approved, but while this work group is working at this stage, they won't be added to the website until have something from this work group, I assume.
Is that what you understood also?
Yeah, I mean, I don't know what I understood. I think that's part of the whole, this process seems to be, my understanding was that there were a couple of those FAQs that may be a little problematic, but maybe we could get the ones that weren't added back in the interim. But I don't know the whole, I wasn't in on the compromise that was reached, but my understanding was that there was some, that was, again, that's an understanding, not a I wasn't there kind of thing. So, yes, sir. Okay.
I attended a little bit of the work group session yesterday, and I'm just, when you say it has to be approved, by whom, or
Go back on the website,
Yeah,
or are we talking
yeah.
about the group? I think legal. I made it, they determined that it wasn't all accurate or in our, for us to put out there. And so this work group, one of their tasks, I believe, is to put something together that does either point or have a document. And once that's complete, then that can be added to our website. But in the meantime, I know that we can't just put them back out there. I can ask again if any portions of them can come off. But I think all of them were pulled out until this work group finished and came up with something. And that may be at the December meeting. It may not.
with regard to that QBS group, is that Carter's? I mean, Carter's right.
Carter,
He drives
yes.
that train. Is that right?
Yes, yes.
Is he around today?
I don't know. I can send him an email and let him know kind of what time we wrap up, or that if we have questions about the group. Yeah.
Well, Robert, maybe if at some point if he can be here, can we interrupt our meeting later?
Yeah, I think that's certainly legitimate, and I think the again, it's an important deal that we're talking about. I don't want to. We had members participating in that yesterday, and there was no clear deliverable or clear dates, or we all just need to get what the direction is, I understand we're trying to come up with a common document, but I mean, we've been now working on this about 4 months or something on something that seems to should have had a little bit more compressed time frame. My understanding was there was a little bit more urgency to finalizing this, and I know everybody's busy. I got it, but if it's a task that we need to complete, I certainly would like to have a who, what, and when type thing to finalize stuff. Ricky.
I sat in on most of that, the QBS meeting, and it looked like the goal was to try to finalize that document to put on the website. The what would be helpful information for both owners and registrants on about QBS, and it sounded like that was trying to be finished up really at this past meeting, and it wasn't quite finished up, so that December, I'm thinking, is thought of as being, let's finish it up. And I would just suggest that as part of that effort of that document that was being redlined and worked on, can we also bring the FAQs back up, and if there are a problem with a couple of them, work them out, but leave that meeting where we know it's okay to put FAQs back on the website.
Yeah, I think, again, that gets back to some of the issue is just what, when, and where, and some of the details that we need to have worked out so that we're not editing, and well, I thought you were going to do this, and I thought this was going to happen. And I think there was a lot of that in that meeting 2 days ago of just on what, and then what we sort of understand our deliverable, sort of, but I'm not sure we understood all the process, and because it was, some people had a document, others didn't. Some had, I wasn't sure of this, others didn't, and that's just an administration organization kind of thing that we just need to close this thing out. I mean, if it's something we're supposed to do, and my understanding again is we had some sort of legislative pressure to finish this thing and to get it done, then let's finish it and not have it hanging over us for a while so that we're be done with it. I mean, we just don't, legislative pressure can turn from pressure to worse, and I'd rather keep it to whatever it is right now and finish the work that we're assigned to do. Comments, questions?
I do want to thank you because I think you were able to kind of keep each section moving of that document so that some of that was accomplished. Thank you.
I think we just need to understand who's on first. Yes, ma'am.
I just want to say I think, Robert, one of the things that I saw was just that because there's people involved that aren't on our board. And so, having Carter be able to corral all of the other interested parties is just so important to the process. And those people were there, and I greatly appreciate their time. And some of them were very, very engaged long before they got to that meeting, and how much we appreciate that. So it makes sense to me that it's hard to get to the finish line because it's not this group. It's a much, much bigger group. So I just want to throw that out because I just want the other people who were in the room who have their own day jobs and aren't part of the board and probably don't share our sense of urgency on it. We appreciate what they're bringing to the table.
100%. All right.
Robert.
Yes, sir.
I sat through that also, and it was kind of my feeling when we left that the video of the meeting was going to be reviewed and red lines made up per our discussions and then presented to us. And I think what everybody's saying is, when does that happen?
And thanks for kind of clarifying that, Frank. And that's what Carter and I talked about after the meeting, that he had access to. I mean, we got access to video too, but he's got access to that. He's got access to the document. and commerce and insurance on whatever level would kind of corral that. But what I don't want it to do is we don't want to have access to that document on December the 5th. And all of a sudden we're trying to finish it up on December the 6th. I think even if it means an interim meeting of the group or something, we need to have a little bit more aggressive time frame and understand when we're supposed to have things done and who's supposed to do what.
Okay, and so that being said, can we make Roxana our bird dog to see that this gets done?
He's writing down something right now.
I'm writing down.
I think
and I'd like to ask you to, if you could follow up with that. And I would say, and this is, by the 1st of November, it would really help us to be of use in this if we can have something to look at.
Speaking of these dates, will all the parties change? Will any parties in this change after the administration change at all? I mean, could we? Which I guess I'm saying more of a sense of urgency to get done in December, that we're not like kicking this with.
And I think that's part of again. I don't think administratively we're going to see changes, but I mean, you never know. I mean, right? But and this board's not going to change in that period of time. But we've got a new legislature coming in January, and this is something that's carried forth from the other. I think the one that the original legislator is he's still going to be there. So it's going to be an item that's going to go on. But what we want to do is finish this task so it doesn't get caught up in some of the other things that may be out there as well. I think that's our concern as well. A very good point is that January is kind of everything changes again, and we need to get this done so that we're not 2 years later still fighting the same fight and going over the same stuff or whatever that is. And it just seems to me. Comments?
You say finish, you mean having a product that the committee has agreed to and that we can present to this board for review at least in advance of the December the 6th meeting.
And I think maybe that's the good point, but I think that I don't know that it needs to be reviewed. I don't know who it needs to be reviewed by. See, that's another question. I don't know who has final approval.
Legal. The legal department will have to look it over.
Well, and then maybe the legislature that
Yeah.
asked us to get together needs to look it over too. I don't know the answer to that question. Yes, sir.
Procedurally, when they asked for volunteers from this board to participate, and it was never my understanding that it was going to come back to any boards for their approval prior to its completion. It's not going to be a perfect document, and I would suggest that we don't try to wordsmith this thing to death, because if we do, it's going to be next year, and we've got some legislative issues that Casey could speak to better than I can. So, I don't know from a legal standpoint or an administrative standpoint if that's going to be the case. I don't think that we have the authority as board members to distribute it to the board. Roxana can find out more about that, but I'm just telling you that I don't know that that's going to be available. So I wouldn't count on it, but maybe you can. But the meetings are open. Anybody can attend a meeting. You were there, and so.
Please, I'm sorry.
At our last meeting, I spoke with one of the ladies with MTask, and I asked her about, the origin of the document. And I think we need to be clear, based on how I interpreted her conversation, that it is not a legal document. It is a guideline, and it is meant for the local governments. It is not meant for us. And we need to make sure whatever we do that we're following the intent and of what the document was supposed to be used for, and not make up what we think it needs to be now. And that's just my comment. So,
And I think this document is supposed to go on our website for our registrants, but we were using that document as a framework to be able to put those things out there for our registrants, not to use it. They'll use their document for whatever they use theirs for, but this helps to clarify But it was just a good framework that had all the steps and had looked to have all the pieces and parts that we need to.
Okay.
And we were trying to simplify that so our registrants would be able to not have to go. Go ahead.
And just for clarification, I didn't intend it for this board's edit, just review. Because we often, very often, get asked questions about responsibilities associated with statements of qualification or requests for proposals or a lot of the things that this document should and will hopefully address. I just wanted to see that document, not to edit it, but just to know and have knowledge of it in advance, so that if there are any issues or questions that any of us have, we'd have the opportunity to resubmit it back to the board for to the committee for clarification.
Right.
We bandied around the word legal here a few times, and I really don't know the legal implications of this. But I would assume that when Carter or whoever he has takes the video and makes the red lines for us, that will have been reviewed in some form from a legal standpoint, so that he wouldn't hand us something we just carte blanche took off the video and wrote on there because that's what we said. I think it would be vetted by the time it got to us. And so I'm not really concerned about whether what is given to us is legal or not legal. And I guess, we're not lawyers. We don't get into that part of the process. And so, I think we need to get that back. That's the first step. And review it and see if we agree with it. And then we can do with it whatever we want.
And it is a public document, so it'll be available for anyone's review. I just don't know that we have the authority to be speaking for the board in any capacity without clarification. And
I think that'll be at the next meeting for the full group to review. But I think
Thank you.
Carter's goal is to get that updated version to the people on the group very soon. So.
Well, and so you understand from some of the discussion what our level of confusion is. When we were given a task to go come up with something that could go on the website that would allow our registrants to know if they were in violation or not. And that's what we've been trying to do. And the longer this goes, and again, not sure who's supposed to put it up, when it's supposed to. There are a lot of those issues that seem to be very nebulous right now, and we want to try to make sure that we bring as much clarity to that as we can. And at the same time of doing what we're supposed to do, which is protect the health, safety, and welfare of the public. And my maintain is, as Brian said, if this continues to go into January, February, March, April, whatever of next year, it has the potential to get caught up in some of the churn that happens as new administrations come in, and that keeps the public and our registrants, in the dark even longer, and we don't need to do that. So we just want some clarification on what the exact process is moving forward, who's supposed to do what, when, and that kind of thing. And we're a very interested body, but we don't have access to the website, don't have access to a lot of things. So you know what I'm saying? We have to have the support of the Commerce and Insurance Administration to help us corral that. All right. Does that sound like a plan moving forward? All right. Interior Design Committee.
We met yesterday morning with 2 members present, and a discussion was held regarding the use of the term interior architecture. The committee requested that legal provide a memo statement regarding the term, and there was an example presented to the committee of a registrant that is using the term. So we're asking for guidance as to what we can and cannot do other than ask the person to stop. So I will file the complaint once we get a response. And can that happen without it being at the board? Can I get an email, a response from legal on that, and then file the complaint?
I'd have to check with Sarah since she's in charge of the disciplinary council role, but I don't think that would be a problem.
Let me make one comment on that, Susan. We met, when y'all met with the engineers, we met with the architects, engineers, interior designers, and landscape. And of course, the topic of discussion was interior architecture. And I guess it was a little surprising to me that what I heard, and correct me if I'm wrong, Susan, but we said this is a problem. We tried to warn you, and rather than say, no, this is the way it needs to be, they go, no, we agree with you that it's a problem.
They didn't see that there was going to be a ripple in the pond. And what?
Who's?
I'm sorry. The interior design program directors that were present. So what has happened is a graduate of the UT Knoxville, and I have to recuse myself anyway, has used the term interior architecture to describe her firm because they have changed the program name and she graduated from there. And that doesn't apply, and the general public doesn't understand that. And so I'm going to have to file a case against her and then recuse myself. But we've got to have, and the schools are surprised that this has happened. And that was, the thing that we tried to tell them, but they didn't see that bigger picture. And so they are telling their students they can't do it. They're making the students sign a statement saying they can't do it. But then those of us that have been out for a long time think, oh, we got a new name for our department. Let's change our name. So that's what has happened. And right now, Chattanooga knows of one other situation. We have one in Knoxville. And what we're hoping to do is kind of nip it in the bud. I am going to notifications to the 3 associations and make sure they distribute that to their members. And maybe we can squelch it before it gets out of hand. But it's not a legal term, and I cannot ignore what's going on. So.
Hold on just one second. Let me get him, and then I'll get you. Yes, sir.
Yesterday at the meeting there, I did take exception with a comment about interior designers are equal to architects, and only difference is they can't stamp a drawing. Well, I made my point perfectly clear that there is a difference between an interior designer and an architect based on their education, experience, and those types of things. And we discussed the violations because of the name change that we're starting to get. And afterwards, and the reason I bring this up is that a disturbing comment was from the gentleman that I had the exchange with. He said, well, what you need to do is file a bunch of complaints, and he said, spank a few people, and he said an example. He said maybe they'll quit doing that. Well, that is absolutely inappropriate, and uninformed, and embarrassing that someone, a department head or a professor, would actually recommend that, because they're creating a problem for professionals that we are not. What we are charged with is, and I don't like the term policing, but we do have to maintain some order in our professions based on the laws and rules, and it's very irresponsible that this has gotten to the point where it is. So that's an opinion that I'm making, in that we talked about this, and then when we get into the legal report, we'll have a little bit more in regard to this. But since you brought it up, I'm just making that statement, and it's offensive to the profession. So thank you.
Tony, sorry about that. I want to get in order here.
I'm sorry. I just wanted to take the opportunity to answer Ms. Ballard's question. Yes, you can file. That was your question. Yes, you can file a complaint. The division SOP says that board should file them in the.
That wasn't my question. My question
sorry.
was.
I apologize.
That's okay. I need to know if.
Good answer, though.
I need to wait until you all give me a memorandum in regards to that terminology, and then file the complaint. Because if there's nothing that we have a tooth into, if you want to call it that, then there's no point in bringing up a case that we close. So.
Yes, that would probably be
better
a better way of doing
approach.
it. Yeah,
Got
I
it.
agree. Thank you. Sorry.
That's okay.
Kathy? Thank you for, so you all are going to come up with a name, go ahead, Kathy, sorry. You're going to come up with a memo for her to file the complaint. Okay, I got it. Go ahead, Kathy.
No, that's okay. I just, again, I read the minutes when we get them out, and a lot of times there's, the minutes say that we had discussions on topics, and that's entirely appropriate in most cases. But in this case, when we're talking specifically about something that is probably going to continue to be an issue, I'd like for this discussion to be documented in the minutes a little bit more detailed relative to the exactly why this has become an issue, the name change of the programs at universities, et cetera, so that we don't get 6 months down the road and forget what Rick said.
We are going to cover a little bit more of this in the legal report, so we're kind of ahead of ourselves here, and we're going to rely on legal to help us on that. So your point's well taken. I just want to make
And
sure.
I have written down as a legal action item, I have legal do research and write a memo as to whether or not the term interior architecture can be used. If the term may not be used, what steps can the board take to stop people from using it, and also what steps can the board take to educate the public? Does that cover your request? Okay. So that's in my notes, and we can make sure that it's in the minutes as well.
Just so you know, a little background. 4 years ago, when the deans presented the concept to us that they were going to change their names, I issued a letter, and they did not. I asked them to not do it until they did it in a legal fashion. That letter went all across the Southeast, and we heard about it at NCARB and NCIDQ meetings and all this stuff. And so 2 years ago, they told us they all had changed their names with the exception of 2 programs in Tennessee. We really don't have any jurisdiction over what they do because it's an approved code with Southern College Board or something to that effect, and I apologize for not having the right name. But what we have been told is that they're telling the students they can only call themselves interior designers, or that is the appropriate name, even though they have a degree in interior architecture under that college. So now we have the issue of people who don't know what they've told the students starting this process of changing the name of their firms. That we know about 2, there may be more. It never occurred to me that this would start like this, but I stumbled across it, so I needed to bring it up to the board. So there's a little bit of history. We asked them not to do it. We don't have any jurisdiction over them. They did it anyway. And we have some of the deans are very supportive, and then others made comments to Rick that you just heard. So anyway.
All right, very good. Landscape Architect Committee.
Thank you. We had a healthy discussion about continuing education, PDHs, and how it's reported. And personally, I would like to see on certificates that we receive that it states whether or not it's a health, safety, and welfare session. I'm not sure that everyone agrees with that necessarily, and it's a hard thing to define in some cases. But this has put me on the challenge of really getting more attuned to all this and putting all this together. But the state chapter of ASLA is very aware of a potential problem with that, and they're also trying to figure out what their policy would be with regard to providing certificates that may or may not have HSW notated on those certificates. The committee has also asked legal to look at our rule and to provide us a little bit of wiggle room. Both I think the architects, engineers, and I believe interior also have the ability to evaluate an applicant and have a little bit of wiggle room in there. And the way that the landscape architecture rule is written, there is no wiggle room whatsoever. So legal is going to explore that for us and come back and have some information on that. Also, CLARB meeting was held last week in Toronto, and while I did not attend, I did participate in a virtual vote of restructuring CLARB, making some adjustments to the overall organization, and that will continue on because the motion failed, so it will continue on. And I believe that's it for the Landscape Architecture Committee report.
All right, do we have any comments, questions? Oh, okay. Next one, Architect Committee.
We met yesterday, and basically everything we've talked about so far is what we talked about in the Architects Committee meeting. We talked about PDH update conflicts, which legal will advise us on. We discussed the possible name use violation, which legal will clarify that for us, and some law and rules classifications on RFP, RFQ items. And I don't want to get into these too much because as we get to the legal law and rules report, then I'm actually just going to turn that over to the legal department, if that's okay with everybody, because we were a little bit confused yesterday, and they finally got us straightened out, so I don't want to confuse anybody anymore. So, gentlemen, do you have any comment? My report is complete. Thank you.
Thank you, Rick. Now we go to the Engineering Committee report, the always interesting Engineering Committee report.
Short meeting. We reviewed 2 applications, and one of those caused us to take a closer look at our policy of accepting CLEP exam for humanities credits. And it's going to cause us to, we decided to look further at revising this policy language and possibly adding this policy to the website. We reviewed our application form for engineer interns regarding senior year students, and we made a revision. We agreed upon a revision that will help streamline staff procedures. And in the future, we note that we want to review the laws regarding the requirements to become registered as an engineer intern and the need for the form. We reviewed a new rule regarding clarifications about out-of-state registrants and what does and doesn't constitute offering to practice engineering or architecture. And we in the engineer committee meeting, we passed a motion to amend the language for what is not considered to offer to practice. And we further discussed this in the Laws and Rules Committee and decided to leave as is for now, but we've got the clarifications to the clarifications noted anyway. We passed a motion to begin the process of developing a definition of engineering. Do you want to say bells or anything, horns peeling? We discussed decoupling the PE exam from experience requirements to allow taking the exam prior to having 4 years of experience. And we passed a motion to request that the staff research health, safety, welfare benefits of decoupling in view of both the states that have done this and also any input NCEES has to report, unless somebody has a comment.
I have a question. You discussed the definition of engineer. I think that's what I heard you say.
We discussed that we would discuss it. No, we made a decision that we would move forward with developing a definition of engineering.
Probably by getting how other people are defining themselves in other states and that type of thing, I guess.
Yes.
Yeah, we've actually tasked Kathy Ware with kind of compiling some of those other definitions and some things that are there to try to come back to us and let us look at that. And we all have to just be honest about the incidental thing is always going to be an issue between architects and engineers, between engineers and surveyors, although I think less on that side of it. And we just need to understand that we need to make flexibility in the language to handle those situations. Kathy's got a great start on it, and I know she'll do a wonderful job at it, especially since I don't have to do it. That's good. Okay, Kathy.
I was not tasked. I volunteered.
Make me feel important when I say that. That makes me feel like I'm king for a little while.
You took his power away.
I took his power away. Ashley, did I get that right, Ashley? Yes. So, Ashley, you weren't here for our meeting yesterday, so this is somewhat for your benefit, but also just to share with the greater board members, is that I had requested for Liz to compile every state that is out there, what they use to define the term, and I had already looked at it and decided that in general there were three parts to the definition. There is the definition itself, what is the practice of engineering. There are exemptions and exclusions that are noted, and then there is now I'm losing my thought. What?
You said incidental.
Incidental, yeah, and then an issue that addresses incidental, and that I would then, if she would just get it all together for me, Ashley, thank you ahead of time, that I would look through it first and then come back to legal and say, I see these as common things that would be good for us, and start to cull the process. My hope would be that before our December meeting, that I would at least have something that I thought we could start as a framework for discussion. And I understand, architects, y'all do want to define is that correct? Okay. So is there a point person for that objective from the Architects Committee to define architecture? Because obviously we'd like to be parallel.
I would like to nominate Frank to do that.
You would like to nominate Frank?
Yes.
I think Frank would be exceptional. As a matter of fact, I would like to task him with that.
I'll warn you.
Thank you.
I'm taking power.
I'll warn you, ours is 250 words or less.
We want to be brief. Right. Well, Frank and I will talk about that. Good?
No, I will get you what.
Okay,
what
good
we're
deal.
Considering. Yeah.
Good deal. So that's kind of the intent.
I guess one other question is: are you including any input from your professional societies?
I'm sure that will be needed, and we'll do. We're not looking to approve anything in December.
Well, I understand.
Yeah, so there will definitely
I'm glad
be.
You're talking about it.
Yeah, there will definitely be the opportunity to get that out, Casey. If you're making a note of that, so we're going to get that out to the membership and allow them the opportunity to weigh in. Okay.
Other discussion on this, on the engineering committee report? All right, Ricky, good job. Consolidated 4 hours worth of work, so I appreciate that. It seemed like 4 hours, maybe it wasn't.
It was 5. It's 3.5.
Grants to Higher Education Committee.
Right. So we had a wonderful morning of presentations from the various schools that were able to attend, and it's good to see an update, and we saw the results of the special grant, which we were happy that was completed, and they gave us a beautiful presentation booklet. Our budget was revised and presented to the board, and it was approved. And we are also asking, because of the increase of 1,200 students across the board's student body, another $50,000 for next year's budget for the grants committee.
So that will have to be a motion approved by the full board. Is that correct? That's correct. And that comes. Does that come as a form of a motion from the grants committee?
Yes.
Okay.
So.
You want to handle that now, or
I will handle it now. The grant committee would like to make a motion that we increase our grant appropriations by another $50,000, raising it to $400,000, beginning in the year 2019 for the fall.
Okay. You've got a motion from a committee, so it doesn't require a second. Do we have any discussion?
Just a quick question. When we make this recommendation, do we typically qualify the need for this to the administration and how it gets back to the education process? Because I know that's a big momentum in our government, and it should be. So I just want to make sure that we're not just saying, hey, we need $50,000, but hey, we need it for this reason, and it's working.
I think yesterday at the committee it was discussed heavily and a lot as to the good and what they presented and the reason as far as increased numbers everywhere. Talked about that as well. This where when maybe at the state parks you wouldn't have been able to be recorded. Both meetings and then even the breakout sessions were recorded. So I think what the universities did, whether they choose to share with their students or not, that's the official record of everything we did.
I think the number of students, correct me, around 1,200 students.
1,200 additional
increase.
students, mainly in engineering.
Right.
And, well, architecture did a significant increase as well. And a couple of programs in interior design increased significantly. But engineering was huge. And, capacity to have them, we looked at multiple programs that are having to add buildings to accommodate their programs. And so I feel like it's justified in asking for the additional funds. And so that being the case. And we also have roughly 1,500 new registrants within our own program, our board. So we're seeing an increase. Students are seeing an increase. So I feel like it's an attainable request. So.
I'm sorry, and I don't want to just blather on, but I just feel like because this is our official board meeting that we should say something very for the record, and that is that the presentations that were made were exceptional. The money that is being spent is having an impact for the citizenry of Tennessee, and I felt like it was a very good spend. And Susan, I just think you should be publicly acknowledged and applauded for having come up with this idea many years ago, and I just wanted that to be on the record for the meeting.
Right. And the last thing I will say about that is this is in line, I think, with a kind of a strategy we've had as a board for the grants process for a pretty good period of time, but B, also in looking at fee reductions that we have for our registrants or potential registrants across the board that we've been trying to undertake, fee reductions over the last 2 or 3 years and other times too. And so it doesn't look like it will impact our financial stability either. And that's another issue that we need to make sure we don't spend ourselves into bad situation as a board. And so we think we've got that covered from a. You don't have to have a second.
We got a
Came from
motion.
committee.
We just need to vote, I guess.
Yeah, we had if motion comes from committee, it's automatically got a second. All right. Any other discussion? Very good. All those in favor say aye.
Aye.
Opposed? So if we can get that request started down the rails, please. Anything else from the grants committee? Not yet. Perfect. Continuing education committee.
Yes, the Continuing Education Committee met yesterday. Couple of items of discussion. One was and I think Blair brought it up earlier, but the health, safety, and welfare being on certificates, and that came up with. I'm on the Landscape Architecture Committee, and Blair and I guess you, Robert, were doing an audit of the landscape architect, and he had written down a lot of HSW, and none of their certificates said that. And so, having reviewed a lot of architectural audits, apparently the architectural seminars, et cetera, that have CEUs say whether they're HSW or not. And so I was kind of surprised to see that these didn't have that. And so after discussing it, and with the engineers and so forth, and apparently the engineers don't have anything like that either, my only suggestion there is in your meetings with societies or whoever has purview over who puts out certificates, that you kind of stress that you would like to see that HSW actually be shown. And I can think even from an engineer standpoint, we're one of 51 states and maybe more jurisdictions and the engineering society that somebody's going to require HSW for everything. I know there's a lot of architectural jurisdictions that your CEUs aren't any good unless they are HSW. And so, I'm not saying you'll get anywhere, but at least try to get it moving in that direction. That would be, Blair.
You're saying exactly what I was going to. An example is those who live in West Tennessee. We are there by Arkansas and Mississippi, and the state of Mississippi requires 12 hours of HSW. And without something on the certificate, it's a tough sell to the Mississippi board. So it just seems like it behooves those who have these sessions to think about doing this, because otherwise applicants, if they're licensed in more than one state, they're going to go somewhere else.
Yeah, Frank, since you brought up the architectural definitions, I think as a collateral resource, AIA would be helpful because they are in charge of our CEUs. NCARB is not, but they review and assign numbers. I mean, this may be a lot more than you want to do right now, but as a collateral resource, I think maybe you could reach out to AIA. Thank you.
Ricky?
My input yesterday was that I think engineering is much more fractured than AIA. AIA's got it so organized in terms of continuing education. For engineers, it's very fractured, and my input was I don't think the different kinds of providers of continuing education, they're so varied and many that I don't think we could be successful in instituting some policy that would actually happen in terms of putting HSW on the form. So my thought is we've got information on our AE board website that says what is HSW for engineers, that it's up to the registrant to look at, that's in the rules. They've got to have 13 HSW hours. That it's up to the registrant themselves to look at the policies, see what is HSW, and make sure they're getting the courses. And then if they're audited, they mark on the form whether it's HSW or not. And I will mention that the engineering definition of HSW is extremely broad, such that almost every continuing education seminar you could go to is HSW. So.
Yeah, and one of my concerns is, the reason for this board is health, safety, and welfare, and the CEUs that we oversee are not CEUs for the AIA or any other professional organization. They're for the state of Tennessee, and since our reason for being is health, safety, and welfare, I'm not sure why any CEU should be. We're working towards changing that slowly, I think. I guess, is there any other discussion on that part? I'm just bringing that up. I think it would be good if you could do it.
After we discussed this some yesterday, I was reading in it, and I come across something I hadn't noticed before, so I wanted to ask Liz if I'm reading this properly. But in 120-05-.04, basic requirements of continuing education, in paragraph number 2, the last sentence talks about at least 13 hours of the PDHs, and that's where we get this HSW thing. But if you read that at the end of the sentence, it says that 13 hours shall address health, safety, and welfare issues and technical competency. So our law, the way I read that, it's HSW and technical competency. So you could argue that it's the same thing, but just thought I'd bring that up. I had never noticed that before.
I noticed that yesterday too. Hopefully, technical competency is health, safety, and welfare. That's.
I think so, but
yeah, I don't know why it's that way.
Your latest rulemaking package removes that provision altogether, and then it is supplemented throughout for all the individual professions. So, for instance, I can just pick one. For engineers, the rule is amended to at least 13 of the PDH claims shall address health, safety, and welfare issues and technical competency. So it remains in there. Same for landscape architects. And it's the same for interior designers. For architects, it's health, safety, welfare, and acquired and structural educational activities. So it looks like. So it looks like on the rule itself, as amended, the architects define. They say, for purposes of this rule, health, safety, welfare, and social, technical, professional subjects of the board appropriate safeguard that are within enumerated. So those are enumerated in their rule. I'm not sure if any of this is helpful. What I'm telling you. Yeah, we have. I mean, we have copies that we can pass out as to what those changes would be. Is the question what is the distinction between health, safety, welfare, and technical competencies, or that they're required to do both within those hours?
We just typically talk about HSW, and I just noted that it's HSW and technical competencies.
I guess the question there, Tony, is why did we add "and technical competency"? Is that for some area that HSW doesn't?
I'm not sure. It seems like your old rule had that, and I don't know the catalyst for the old rule, and it was remained in the new rule. So I can't answer as to the why. I can't answer why it has why it issues both. This just told me that the old rule, current rule that is about to be changed has been in effect there since 2005. I don't know at what point why it changed. For interior designers, you all have, in your rules, you actually have defined what is health, safety, and then welfare separately.
Because we have fewer courses available.
I guess these are good points to review, maybe possibly for future revisions, but
To answer your question, the way I read it, it appears that those required hours, such as 13 hours, shall address health, safety, and welfare issues and technical competency. It could be a mixture of all of health, safety, welfare, and also technical competencies. I don't know how someone actually does that. I'm not sure, but yes, to answer your question, it would allow for any of the mixture of those within the 13. I was trying to see if there was another definition that I'm missing in here that would help explain some of that. I'm not seeing one. What I have here.
Vicky, I think you were next.
I think the way I've interpreted it in most other states, that I've licensed in and see. Technical competency is part of health, safety, welfare, because you're properly designing the bridge not to fall down. So that's good. But it would also, it also includes classes you may go to about life safety codes and that sort of thing. Of course, it wouldn't include something like proper professional liability insurance, or perhaps, or like how to make your bottom line better, business kind of things.
Excel for engineers.
Excel for engineers, but our policy, under our policy, at least for engineers, that might fall into HSW. So I kind of dread saying this, but perhaps we should review our HSW policies that are on the website. I think that they're not appropriate.
But Susan?
This is just a suggestion. The Interior Design Association has a clearinghouse, a national clearinghouse for all of our continuing education. So it is vetted through an individual organization. It is assigned a number, and it is given a level of competency as well as whether or not it's HSW. And so those are sent to me when I'm reviewing. So I know automatically it's got that stamp on it. And that might be something engineers want to look at doing. As organized and as wonderful as you all are, to have someone that you pay a nominal fee to take care of all that. Just a suggestion.
Beat this one to death.
Yeah, I think we need to look at that and see. I think the reality is, in most cases, HSW you can twist and turn that for a lot of different topics. And we were talking about Excel for engineers, where you may end up having to have some issue where you have to use an Excel type file or something that helps you calculate something for HSW. I don't know, but I think you can make that be a lot of different things if you want it to be. So let's talk about that at a future rulemaking and as we go forward.
Okay. The other thing that was discussed had to do with carryover hours, and I think Tony has in our proposed rules, and I think Tony has a fix for that. I know that's going to be brought up in the Laws and Rules Committee for a motion, and so I'm going to let that go to that committee. Unless anybody else on the committee has anything, that's our report.
All right. The next is Laws and Rules Policies Committee, otherwise known as the What Tony's Going to Say Committee.
Tony, can I make just one comment? I had omitted one item that I think you're going to cover. I just want to bring it up. It's the Liz brought it up yesterday. The procedural qualification on the term architectural associate. There is a conflict that she's discovered. So other than that, I'm turning it over to you, sir. Thank you.
Great, and I think Liz is passing the text out. The chart, Liz. Do you want me to pass that out? I'm not sure. You're doing yours first. Okay, right.
I can go in either order. I just thought I would pass it out.
I understand. Yeah. Sorry.
I've just passed out a new version of Rule 0120-01-.03, which is now called Clarifications to Offering to Practice. So we had a lengthy discussion yesterday about the history and timeline of the Clarifications to Offering to Practice rule, and I mentioned how it was filed, a subsequent rule package for the architectural associate term, and also changes we made to the co-op credit allocations. were submitted to the Secretary of State and kind of crossed at the same time as one of our other previous rule packages, which procedurally made the subsequent rule package containing the architectural associate term and the co-op credit package be incorrect, as they didn't contain the most up-to-date, current, and effective rules, which, if they would have gone through, would have reverted our rules back to the original language. So in order to correct that procedurally, I will need a vote from the board to approve severing the architectural associate rule amendment from the rule package that contained the architectural associate and the co-op credit. We will take that off of that rule filing and allow the co-op credit portion of that rule to move forward and go before the Government Operations Committee for their approval. And then we will resubmit the architectural associate portion separately so that it doesn't hold up the co-op credit amendment. And that's what you're seeing here. I have put the architectural associate amendment with the new current rule language under clarifications to offering to practice. So I know that was a little bit confusing, but hopefully now that you're seeing it in front of you, you've got in black the current effective language under Rule 0120-01-.03. And if you'll look at paragraph 3, you will see the addition of the architectural associate amendment that we had made previously but are going to resubmit so that it doesn't procedurally mess anything up.
So what we'll need there, I mean, this is laws and rules, but laws and rules never passed a motion to this effect yesterday, I don't think. So we'll need an official motion from the board. Basically, and what you said before was to separate and allow you to refile.
Yes, I'll have to withdraw that's the official term, withdraw the architectural associate portion of our rule package that contained that amendment and the co-op credit amendment and resubmit it separately.
Have a motion along those lines?
I make the motion that we accept the recommendation.
Second.
Now, any discussion on that? I will make a comment much clearer this time. We got all. If you limit this,
Took me 3 times.
Well, when you limit engineers to one color, we're better.
Okay.
Okay. And before we had 3, so it was a little bit more confusing.
No problem.
But thank you very much. That's good. Any other discussion? All right. All those in favor say aye.
Aye.
Those opposed? The ayes have it. Thank you. Okay, back to the laws and rules / legal. What are we on next?
I'm turning it over to Tony. We have the option, other items previously discussed in our other meetings or reports.
Roxana is passing out a copy of the rules package, and this is the rules package that's currently being held up because of until we look at and create a fix for the architect's amendments. In order to give a visualization of what it is, I've created a spreadsheet that basically what it does is it tries to abbreviate what all those rules, what the changes will do. So on the top, on the spreadsheet on the top in yellow, it has what is the current rule. It says previous rule, but that's the current rule. So if you look at it, that's the current rule in yellow. It applied to all of the professions, and it was all the same. Below that, you'll see where it says architect new, engineer new, landscape architect, and interior designer new, and that would be the new rule. The headings across the top, first biannual, that is a category where it's the PDH requirements for a first biannual renewal. and then the subsequent biannual would be after that, and then and then you see new registrants, which is the PDH requirements for a new registrant, then reapplication, and then the last is the alternative approach, and we'll have some discussion on that, which is an alternate approach to obtaining the PDH on a different timeline. So I have created this spreadsheet so that as I'm explaining it, you may be able to see the big picture of everything, and how it actually would affect each of these professions. So, and I had to create that spreadsheet in order for me to actually understand what the issue was. So, I'm definitely a visual person. So, if you look through the red line package that you have in front of you on the second page, you'll see basic requirements for architects. And what you'll see is that if you look through A basically starts to say a registered architect seeking biannual renewal shall, and it has the language of what it does. That is essentially summed up under subsequent biannual on the chart for architect new. And so if you look at that, you'll notice that below it are all of the subsequent biannuals on the chart for engineers, landscape architects, and interior designers. And you'll see that they differ. So the issue had become is that when this rule was sent up for further review at a level beyond me, the question was, does the architect's rule as amended create a difficulty or impossibility for a new registrant, let's say someone who becomes registered in July 2018, to actually meet the PDA requirements when they renew their first biennial in July 2020. And the rule as amended, if the rule as amended was passed, then it would require 12 PDHs per calendar year under architects. Well, if you were first licensed in July 2018, your licensure period runs across 3 calendar years. Half of 2018, full of 2019, half of 2020. And the legal definition of a calendar year is January through December. So it creates a little bit of an impossibility for somebody who was first registered in July 2018 to get 12 PDHs per calendar year. They'll actually only have 1 calendar year in which they could get 12. But it's quite possible that they may not get any of those PDHs when the rules pass until the first 6 months of 2020. And basically upon renewal, they wouldn't have met the PDH requirements. And so we have created a potentially bad scenario for some registrants out there who may have just got registered last month or a couple months ago and intend to do the right thing. They're just not going to be well informed when they start doing their PDHs. So you can see across there that the architects under first manual, they have no provision for a first manual renewal. They would follow the subsequent, and then if you look all the way to the end on alternative approach, the architects as amended here do not have an alternative approach. In order to correct the scenario, my recommendation is that we amend the architect's language of the rule to mirror that of engineers, landscape architects, and interior designers for the first biannual, the subsequent biannual, the reapplication, and then on the alternative approach to make their alternative approach, create an alternative approach that mirrors the other professions, except that it would have 12 health, safety, welfare credit requirements, but the 12 being health, safety, and welfare. If you flip through it becomes obvious as to the difference in the language when you flip through the rulemaking, where architects is glaringly different from the way that engineers set out, and then interior designers, and then landscape architects. I'm not sure how we came to that when the rules were adopted by the board, and I apologize that we didn't catch it earlier, that it's late in the stage, but I am glad that we caught it. And essentially, what we're asking, I'll just state it again, is to approve an amendment that would allow for the architect rules to be amended to mirror the rules of the other professions as is in this rule package. And we would appropriately amend that so that it does reflect, to allow basically on a first biannual renewal and then on a subsequent biannual renewal, it would be 24 PDHs in 2 calendar years as opposed to 24 PDHs in 2 years as opposed to 12 per calendar year, and then also adopt the alternative approach. It would still continue to have, prior to 2021, there would still allow for 12 carryovers, and then after 2021, as all the professions have adopted, there will be no carryovers to be allowed. Should fix the issue so that new registrants or people who are recently registered who are renewing don't run into the scenario of turning in their PDHs and it looks like they actually cannot meet the requirements in order to renew.
Alternative approach column only dealing with the first biennial?
No.
Okay, I'm a little confused in that I thought you said the architect language was being changed to mirror the other professions, yet it looks like the alternative approach for the engineers and landscape architects and interior designers are different than what I see in the subsequent biennial column. So it seems like those trades have changed and not the architects in the text. Now it's 24 PDHs in 2 years with 13 HSW, and then the alternative approach for those three professions is changed to 12 PDHs and 7 HSWs.
Correct. That is correct as how it was changed.
Right, but I was thinking you were saying the engineer, landscape architect, interior designers were not changing. The architects were changing to be like the other three.
I'm not sure if I'm going to be able to answer
Okay.
your question. I may be able to just restate it. I don't know if this is going to be helpful, but
Okay.
If that's what I said, what I intend to say is that we would suggest the amendment that the architects amend their rule so that it would allow an alternative approach that looked similar to what you see under engineer, landscape architect, and interior designer, because those are the amendments that are in this rule package for engineers, landscape architects, and interior designers, which is the 12 PDH per calendar year, 7 health, safety, and welfare.
Wouldn't it be more like the interior designer version, 1112?
Sorry, yes, except for that, I did say that earlier, and I kept repeating that yesterday, that it would be 12 PD. The alternative approach would say 12 PDHs per calendar year, 12 in health, safety, and welfare.
Architects, interior designers, and then the engineers and the landscape.
Yes, it would be 12. That's what the difference would be. What you're seeing right there is not the suggestion. That's what, as the rule is written right now, that's what you would get. You would not have an alternative approach. And I think was the way it was created like that, because essentially what the subsequent biennial would be similar to what the alternative approach is. So we're just going to essentially move the subsequent biennial over to alternative approach, and under subsequent biennial we would create a rule that mirrored engineers, architects.
Under subsequent biennial, it'll have, instead of it will be a registration date renewal time, and under alternative, it'll be based on a calendar year for everybody.
Yes, because
that's what we're trying to do.
That makes sense.
Yes.
Got it. I understand.
24 months as opposed to per calendar year.
Yeah.
I see it.
Yeah. Because I think the reason we all did this was obviously multi-state registrations. It was easier to keep up with on a calendar year basis, but there are individuals that are registered in one state that may just want to continue on doing it based on their registration date when their license comes up for renewal. But it gives both alternatives to do that and makes it easier for multi-states to. And I think I think sometime in the future, we will eliminate probably the registration date and all go to calendar year, would be my guess, because I think that's what the national organizations to help on mobility and all that will kind of all get to that point at some point in time. But right now we're kind of in that interim phase, it looks like. So does that make sense? Anything else? That's good. I'm glad you gave us a flow chart here, a thing, yeah. Beatty, any comments?
No.
Brian, you had?
I actually was going for, but I was actually about to make a motion that we accept legal's recommendation.
I'll second that.
Okay. Other discussion? All those in favor say aye.
Aye.
All right. Thank you very much. That's good. That'll move us down a little further to doing it like everybody across gets us in that point. So
I did want to give the board some good news regarding rulemaking. Your seals, indexes for digital signatures rules, we brought that to the Government Operations Committee last week and answered questions with the senators, and they ended up putting it on the consent calendar and approved it. So that rule will be effective October 23rd.
very, very good. Anything else from laws and rules?
Where did we leave off on the name use violation for architectural interiors?
They're going to give us a memo about.
As we discussed yesterday.
Yes.
Today, yeah. Okay, I'm sorry. It was just still on the list, but we've covered so many things across the last three committees. I'm just kind of like yesterday. I'm a little confused. So, but anyway, thank you, Tony. Are there any other issues, comments? Then close the Law and Rules Committee meeting.
Very good. Again, thank you for your work, Tony, on this, and everybody. That'll get us in good shape. Finance Committee.
Thank you. Finance Committee met yesterday, and at today's meeting, we've already discussed the two major items. Roxanne has already covered the financials, and given we have the numbers back from July, we're right on track, I believe, with where we should be financially. We also discussed the request of appropriating $50,000 additional dollars in the Grants Committee. So it was part of that discussion. Other than that, if anyone else on the committee remembers anything
Yeah, I think it looks like for those that I should have seen during our time, but financially, again, we're in good shape. And just as a reminder, that's one of the indices that we're measured on when it comes time for sunset and renewal of this board, is to see where we are from a solvency standpoint, as well as how we're meeting our different metrics, and we try to exceed what the expectation is on that, so to make sure that our board continues to operate. Next one, Outreach Committee.
Outreach Committee did meet yesterday. No actions to be brought before the board. We did discuss, as far as the publications, the billing officials manual that's on the website. I guess we've been preoccupied with other things, and just I brought up did anybody know of a reason that it needed to be reviewed, and I think Liz made a note on that. We didn't do anything with it at that point, but it might be something for the future. We discussed outreach activities. We're always looking for ways that we can encourage licensure with a cross-section of the public, so we're looking for ideas, ways we can do that. We also talked about meeting with the deans and program directors yesterday. Obviously, everybody thought that was a success. We interested in continuing to do that and maybe even doing it more often. Several in the group felt like we ran out of time, and maybe we should consider other options for that. So that's our report.
Any other comments from anybody about outreach? I will say one thing about the meeting with deans real quick. It was interesting. I think one of the presenters talked about for the FE, and I'm sure there's others, how they gave the money to their campus organizations, their campus societies. And it seems like that peer pressure seemed to work to get people to take the FE. So I thought that was a really unique approach that we may want to tell others about that didn't get to see it. Okay. Now we're down to general discussion. And anything, Roxana, that you know of on, I think we've talked future plans. We've talked about the board meet or the NCARBs and all the stuff coming up, so that the zone meetings, we need to get that. A topic list, you sent us out a topic list, but I think we went through a lot of that during our committee meetings. Is there anything else that we didn't get to during the board meeting?
I could take advantage of having everyone here. I think Wanda did a great job and printed us the list of committee appointments. I think it's been a tradition at this meeting, if anyone wants to come off of a committee, be added to a committee. Are there any changes that anyone is aware of for us to update this? And that way we will have it for all the meetings, and we'll make sure to get it to the right people.
I've had a request by Alton to come onto the Grants to Higher Education Committee. It's good. We've got 4 members on the nomination committee. I don't know. Typically, good committee's needs to have 5. I mean, that's a positive thing to have. You get 2 votes. Well, that's probably another reason that we need to have 5. And Grant, if it's okay with you, I'd like to put you on that one that'll kind of finish that. That'll give us a 5-person committee, which again, I always think is a positive thing. It's usually a really contentious committee. Do you want to? Yes. Do you want to? Okay. All in favor. So, and besides that, I think several of these are dictated by what we've got in our policies and stuff.
Perfect. Thank you.
All right. Thank you. Our next meeting is December the 5th, right? Are you looking at me like I'm supposed to say something else? Okay. I've had that look from a female at my house a lot of times, like, you're supposed to, don't you remember? And I don't remember, so I'm just trying to, whatever. December 5th, we will meet at 1 o'clock. And then we have the QBS thing. Thursday afternoon is the other part of that. Historically, we've had, we'll talk about this offline, but just to kind of the Christmas thing, so we need to, there was some thoughts the other day about a little different twist on that, so we'll see what that needs to look like. Anything else? Alton, thank you very much. You kept your comments brief. I appreciate that. All right.
Make a motion, we adjourn.
Make a motion, and everybody have a safe trip home. We adjourn.
Second.
Thank you.
Thank you.
All right.
Good to see you, Sam.
Good to see you, too.
Mimsav, thank you very much. Actually, Mr. Chairman, you did well. We're 43 minutes early.
I'm really good at this.